Recording in progress.
Hi, Noltando.
Good morning, Chair.
Hi, good morning. I'm trying to open my video. It's not, you cannot start your video because the host has disabled it. Can you disable the video?
All right, Chair, I'm trying to.
For now, so that, but I guess in the meantime, we should,
Yes, you can now start your video, Chair.
no, it says no. Let's get started. I think we can ask IT people to sort it later. Am I audible?
Yes, you are audible, Chair.
Yeah, good morning. May you fly to the agenda, please, of the... Oh, yeah, there's the agenda, honorable members. I think we should start and continue with the meeting as they are sorting the video things. Where I come from in Stukunil, and there's a saying that goes like, that when you talk to people, you need to see their faces and see reactions on their faces. But, yeah, thank you very much. Let me welcome everybody on the platform and say, there's the agenda, are there additions on the agenda? If none, can we get mover for adoption of the agenda? By show of hand or by raising of your voice, we may have progress. Any mover for adoption of this agenda? Or before we even check, I think we have a quorum, and I think we do, from... Do you have a quorum for the meeting, Noltando? I thought we did, but I guess I don't think we are.
I just checked, Chair. We've got only 3 members for now.
Yeah, oops. Can we just no, as we fix the video, the video, and with the IT people, maybe this other members will be able to join in. It could be one reason or the other that makes them not to connect now, but let's just hope that they will in the next 2-3 minutes. Are there some who are on the waiting room? I am in the meeting, and the next person is who is the iPad? There is one who is registered as the iPad.
Good morning, Chair. It's me. I'm trying to rename the iPad. I'm battling a bit. Good morning, Honorable Chair.
No, thanks.
Yeah. It's Matanzi Mamoeli.
Yeah, welcome, DJ. Always welcome. Yeah, it's only the three of us.
I'm quickly trying to check the other members, Chair.
Yeah, just check with them. It's showing into our time. And
We are now short of one member to form a quorum, Chair. Honorable Njadu is trying to join.
that is the last member will give us the quorum.
Yes, Chair.
All right, and I think now I think we can continue with the meeting. Good morning, everybody. Very good morning to our guests. There's the agenda. This is for honorable members. Is there any mover for adoption of this agenda and the program for today?
Chair, I move for the adoption of the agenda as it is.
Yes, Honorable Ndongeni moves. Any seconder? Can we get any seconder for? Is there any seconder for the adoption of the program? Eva? Oh, all the members seem to have been, they all dropped out of the meeting.
I second, Chair. Thank you.
Oh, thank you. Thank you very much. Let me take this opportunity to welcome our guests and just apologize for this logistical and technical challenges that we have with our connections, and and that say we welcome amongst us here. We have we'll be having 8 presenters representing 8 institutions. Ms. Alana Bailey will be representing AfriForum, the Independent Schools Association of Southern Africa, SAOU, that will be represented by Dr. Louis Swanepoel, Consent Young People of South Africa, represented by Dr. Elfrida Fleischmann, Western Cape Forum for Intellectual Disability, represented by Ms. Vanessa Jafta, the FEDSAS, represented by Dr. H.J. Dickin and Ms. Juan van der Merwe, South African Education Development Trust, SAAOT, represented by Suzanne Mellet, and ActionSA, represented by Mr. James de Villiers. I am taking this opportunity to welcome you to this meeting of today on our program. And the basic education laws amendment that popularly known as the Bella Bill, Chapters B, 2B of 2022, was introduced to the Select Committee on Education, Technology, Sports, Arts and Culture of the National Council of Provinces on the 8th of November, 2024. The department took the committee through the clause-by-clause proposed amendments within the bill and the clauses which were amended after the National Assembly public participation process. It is with this background, members, that the NCOP decided to conduct its own public participation to get input from all stakeholders on the amended version of the Bella Bill. Since this bill is a Section 76 bill, it was referred to the provincial legislatures to also embark on a public participation process in the provinces, whereby members will eventually return with negotiating mandates from their respective provinces. However, Due to the high public interest in this bill, this select committee on the SOP has also called for the written submissions from the public to provide its input on the bill. Upon receiving the written submissions, we felt that it is also important to invite stakeholders who requested oral submissions in order to listen to their concerns and drive a robust dialogue on this highly interesting bill. We will therefore like to thank all the organizations to avail yourselves to contribute to the shaping of the future of South African basic education. We hope that these oral hearings will be a fruitful and provide a meaningful engagement. I thank you all and all welcome, as I said. And the, let's say, the ground rules is that all the microphones will be blocked, and the only microphone that will be working will be that of the chairperson and the person making the presentations. And that if members want to say something, they can raise their hands through the raise your hand facility. And let me invite our first organization on the agenda, which is AfriForum, as represented by Mayor Alana Bailey. All organizations and presenters will be given 30 minutes each. Thank you very much. And I'll ask the table to help me with the time also. Ms. Kaka. Over to you, Mayor Alana Bailey. Your 30 minutes starts now. Thank you.
Good morning, Chairperson. Thank you so much. On behalf of AfriForum, I would like to thank you and the members of the Select Committee for the opportunity to present this oral submission on the Basic Education Laws Amendment Bill, which I will call Bella henceforth. AfriForum's unabridged submission was submitted to you in writing, so permit me the opportunity to present you with a brief overview today in order to adhere to the allocated time. Just to recap briefly what our interests are as AfriForum, we are a non-profit company registered as such in the Republic of South Africa. We are a very active role player in civil society with primarily stated objectives, including the promotion of democracy, the activation of civil society, the participation in political life and public life, and also the promotion of constitutional rights in South Africa. At the moment, we have about 315,000 active members. They pay a membership fee every month, so we can control the numbers. And that makes us one of the largest civil rights organizations in South Africa. And a sizable number of our members are either parents of children or prospective parents of children or grandparents of children who attend primary and secondary public schools throughout the Republic. As an organization that promotes constitutional rights, AfriForum has a direct interest in the proposed amended legislation, which will have far-reaching implications for the existing powers and functioning of SGBs if it should be adopted. Our comments are also made in the interest of our members who are parents of learners, but also people who are participating in SGBs. Certain of the proposed amendments threaten the success and optimal functioning of especially public schools that provide quality education to learners and have proven to be successful through major and additional expenses borne by the parents of such learners in order to maintain the public infrastructure of public schools through the SGBs, besides appointing additional educators from their own financial resources in order to improve the educator-to-learner ratio of public schools in the interest of quality basic education. AfriForum is concerned that the objectionable bill amendments will result in the discouragement of parents of learners to be involved and committed to the functioning of SGBs. SGBs which they had elected may no longer be able to perform its functions in partnership with the state, but may instead find that its functions and powers have been taken over by the increased state control. It would potentially serve to undermine the trust and confidence in the public school system to continue providing quality education in those schools which have thus far been able to do so by means of proper management and governance by the SGBs. AfriForum's criticism are based on careful consideration of the educational impact on all members of society dependent on education in public schools. It is also based on consideration of the judgments of the Constitutional Court in their full extent. The comments are further based on educational research by leaders in education who have published on the subject and on the importance of rather strengthening the participation of parents and communities in public schools instead of eroding the powers and functions of SGBs. And now for some of my personal observations. What has become clear to me during all of the public hearings that I have been attending since 2022 is the public's passion for the education of our youth. Parents, teachers, community members, and even children themselves have made sacrifices to attend these hearings and to speak about their expectations of the education system and to which extent this bill addresses it or fails to address it. We are concerned by the fact that many of their most serious concerns are in no way addressed by the bill. They speak of overcrowded classrooms and the ensuing low-quality education that children receive in these classes. Clause 4, read the transfer of the final decision-making power on schools' admission policies from the SGBs to the provincial heads of education, will do nothing to alleviate the overcrowding of classes, but instead it poses the very real threat that when departments fail to provide sufficient classrooms to place all applicants at the beginning of the school year, this may provide a quick fix to cram more children into the existing schools. We constantly get complaints about temporary classrooms that de facto become permanent. One of the worst reports that we've recently received is about temporary classrooms where there are literally holes in the floor through which snakes have entered the classroom while the teacher was teaching. The school in question is simply told that the province doesn't have money to provide them with permanent classrooms, and we think this is a situation that may be exacerbated if Bella is accepted in its current form. We've seen schools where more than 100 learners are crammed into a single class. Their health and the health of their teachers are at risk, and yet this very same school has been told that it should accommodate more children from a neighbouring school which the department wants to close down. We see a growing need amongst all South African language groups for mother language education, once again something about which the National Department has made many beautiful promises but have provided very little practical plans or implemented such plans. Yet now it wants to transfer the right to decide on the language policy of schools from the democratically elected representatives of communities to provincial heads who will in turn pass it on to an official who will not have the same understanding of the community serving and being served by the school in question. A researcher has found that since 1994, there have been 12 cases of language policy disputes in schools, and in all of the cases, the heads of department failed to consult with the school communities. So why would the outcome of an implemented Bella be different? We ourselves have been witness to some of these cases. The constant threats against schools and their staffs, especially Afrikaans single medium schools, the use of children as political pawns, the denial of the department's responsibility to provide adequate facilities and expand mother language education. In other words, not only teaching the languages, but using them in single language facilities as languages of tuition and learning is required. Why single learning facilities? Because when combined with another language in either dual or parallel medium instruction, the strongest of the two languages will eventually dominate and exterminate the other language. This has been proven time and again all over the world, and yet we want to subject our children to the same experiment in South Africa by creating more parallel and dual medium institutions. In 2019, the United Nations Forum for Minority Issues consulted internationally with language rights and education experts and produced a report instructing member countries of the UN on their obligations to minority languages in the countries in respect of education. Their recommendations included that countries should provide education at all levels, in other words, even at tertiary level, in minority languages where feasible and funded, in order to make sure that both at the public and a private level, these institutions are adequately funded. It also included that transport should be provided for the children, especially children in rural areas, so that they can attend schools in their mother language. Parents should be made aware of the benefits of mother language education, it was said as well, and that staff and learners at these facilities should be protected from any form of discrimination. Finally, even that where the demand for mother language education diminishes amongst a language group or community, the state should encourage the community to increase its demand and revitalize its language, as languages are national treasures and not only mediums of communication. Our languages shape our thoughts, transfer knowledge, and are part of the national diversity which South Africa supposedly embraces. This awareness of the role and importance of language and the state's obligation to its diverse language communities are not evident in South Africa, and instead we constantly get complaints from schools about the pressure from the department officials to become more English. I will deal with the Constitutional Court's judgments in this regard later, but first more on parents and communities' expectation of education laws. Apart from having the final say on admission and language policies, communities want to see better discipline in schools. Good teachers are leaving the profession as they report that in some cases they are threatened by some of the children, and Bella does not address this. Bullying and violence in schools is an increasing problem. Bella does not deal with it. Some parents prefer to homeschool for many reasons. Measures in Bella, however, are so strict that it will discourage this choice instead of supporting parents who choose to homeschool. Parents plead for education that emphasizes morals and ethics, but instead, Bella will serve to erode the existing and already diminished religious ethos in schools, to name but one example. Teachers are overburdened with administrative work and spend an ever-decreasing number of hours per week on active teaching, and yet Bella does nothing to decrease their workload. In fact, it may even add to their workload. In 2020, the world of education changed dramatically. Hybrid schools and hybrid school models have become the new normal and presents us with exciting opportunities, if applied beneficially, as does the ever-increasing offer of artificial intelligence education aids, and yet Bella was drafted before 2017 and does not address this at all. It is already so outdated that one could even call it irrelevant in some aspects. That then some of our observations based on the research and practical experience gained all over South Africa and in discussion with international experts. AfriForum would like to emphasize that certain of the proposed amendments, in particular with reference to the admissions and language policies in sections 4 and 5 of Bella, go against the very core of the public school model and foundation principles and objectives on which the South African Schools Act of 1996 is founded in respect of public schools. As such, they are not rationally linked to the overall purpose and objectives of SASA. Therefore, certain of the proposed amendments will undoubtedly run risk of being declared constitutionally unlawful. Should the proposed amendments aimed at eroding the policy-making powers and other powers of SGBs be enacted by Parliament, it will be a regrettable and regressive step towards more state control over public schools, thereby subverting the fundamental partnership model envisaged by the Schools Act between school communities that consist of the parents, the staff, and the learners, and provincial departments and the National Department of Basic Education. It will be destructive of the fundamentals of such a partnership model, which evolved from the apartheid era of complete state control into the new constitutional order characterized by more community involvement and their participation. and the decentralization of powers to SGBs in respect of the governance of public schools. It will be destructive of the advantages which are inherently part of a decentralized and community participation model in partnership with the state, both nationally and provincially, as it exists in its current form in terms of the Schools Act, which are all aimed at the provision of education of progressively high quality. The proposed amendments, if adopted by Parliament, will subvert core elements of the grassroots democracy principles of school governance by means of democratically elected SGBs, which have also been described thus by the Constitutional Court in various judgments on basic education, which are all also included in the written submission that was sent to the committee. It would also be contrary to stated objectives of the South African Schools Act, where it is stated in the preamble that the aim of the Schools Act and the National Department of Basic Education is to set national norms and standards for the education of learners and the organization, the governance, and the funding of public schools. This means that the state is involved at macro level and should not interfere at the grassroots micro level of the existing functioning and powers of SGBs, unless where such national norms and standards, including those of the Schools Act and the Constitution, are not complied with. In this regard, the existing provisions of the Schools Act, read together with the key judgments of South African courts, coupled with the constitutional principles of cooperative governance, provide adequate safeguards, checks, and balances to intervene where necessary. It is by no means clear why changes in the policy by the national executive are deemed necessary. It would erode the previous policy-making powers of SGBs in terms of admission policy and language policies. There is no constitutional difference in terms of Section 29(2) of the Constitution between public schools and public universities. And in the latter case, with universities, there is a broad national ministerial language policy framework with the power to adopt a language policy vesting in a democratically elected council of a university. So in this regard, the same powers exist by means of the Schools Act in its present form, with the SGB being democratically elected and having powers similar to those of an organ of state. So why should it change between tertiary level and primary and secondary level education? AfriForum urges the provincial legislature to carefully rethink the proposed amendments dealt with in our submission, especially clauses 4 and 5, and rather to focus on ways and means through which less state control can be introduced, and the decentralization model can be even further strengthened and improved. By rather increasing community participation with parents and educators in partnership with the state, the quality education of children would be strengthened, thereby promoting the best interest of the children and their rights to access quality basic education to an even greater degree. Where school communities are less resourced and have less capacity, for example, when we talk about no-fee schools, the national, state and provincial authorities should rather direct their involvement and support towards such public schools in accordance with the constitutional principles of cooperative governance in terms of Section 41 of the Constitution, and concentrate their efforts on promoting and fulfilling the rights in the Bill of Rights as required by Section 7(2) of the Constitution, rights which in this context are in the best interests of children and the right to quality basic education. With all of this in mind, AfriForum has even made use of the opportunity to propose other conceptual amendments to the Schools Act in our written submission submitted to you, which could introduce a whole new chapter of quality education to all communities in the country. Unfortunately, time does not permit me to outline these proposals, but you have it in the written submission, and you are welcome to engage with AfriForum in this regard at another time. Now, as promised, I would like to refer to certain key decisions of our courts, including the Constitutional Court, with reference to basic education and public schools, the specific design and model of public schools, as well as the different roles and responsibilities of the various role players namely the state, the SGBs, parents, principals, and provincial departments. The judgments of the Constitutional Court and its pronouncement on the balancing of these rights, powers, and functions of the various role players in education already serve as a pronouncement of the law on the existing provisions in a balanced and guiding manner. This once again begs the question why certain key elements or key amendments are proposed at all, especially in relation to the interference with policy-making powers of SGBs. It begs the question what the underlying political agenda is with certain of the proposed amendments and what the supporters thereof seek to achieve. The courts have not identified any shortcomings in the legislation which would necessitate or prompt amendments regarding the policy-making powers or other functions of the SGB, and yet Bella proposes to amend or change this. In the written submission, you will find several relevant extracts from judgments of our courts. Because of the time constraints, I will refer to only some of these. The first, in the case of the head of the Mpumalanga Department of Education and another versus Hoërskool Ermelo and another of 2010. The Constitutional Court per Judge Moseneki, with reference to the overall design of the legislation and the role of governing bodies, said the following, and it's in paragraph 57 if you want to study the judgment. It accords well with the design of the legislation that in partnership with the state, parents and educators assume responsibility for the governance of schooling institutions. A governing body is democratically composed and intended to function in a democratic manner. And now the next part I emphasize. Its primary function is to look after the interests of the school and its learners. It is meant to be a beacon of grassroots democracy in the local affairs of a school. Ordinarily, the representatives are parents of learners and of the local community who are better qualified to determine the medium best suited to impart education in all the formative, utilitarian, cultural goodness that comes with it. Then in paragraph 79 of the same judgment, the Constitutional Court also said the following with reference to language policy. School governing bodies are a vital part of the democratic governance envisioned by the Schools Act. The effective power to run schools is indeed placed in the hands of the parents and guardians of learners through the school governing body. For that reason, the starting point of our understanding of the role of the governing body and of the state in relation to language rights and public education is Section 29 of the Constitution. Section 6.2 must be construed in line with the constitutional warranty. The Constitutional Court in Ermelo also pointed out that in the scheme of the existing legislation, the powers of the SGBs are not absolute, and that in certain circumstances prescribed in the Act, the function and functions of a SGB are not immune from intervention by the head of department. That is the current position, and there is no good reason to devise more provisions and mechanisms to curtail or override powers of SGBs by affording the authority to the heads of education and the heads of department in the provinces to approve admission policies and language policies. That then about specifically sections or clauses 4 and 5. Apart from those objections to 4 and 5, we specifically also identify concerns about clause 7C and D, that is the amendment of Section 8 of the Schools Act, exemption from Code of Conduct. We feel that subclauses 7C with its present wording with reference to an application for the exemption from complying with the Code of Conduct on grounds of just cause shown is too vague, which can lead to abuse, can cause insurmountable difficulties for public schools in the enforcement of their disciplinary codes of conduct. And AfriForum proposes that the words just cause should be placed with narrower grounds, such as on fully motivated bona fide religious, cultural, or medical grounds. We also do not agree with the current wording of clause 7D. It would be sufficient to determine that the disciplinary proceedings should comply with fair administrative justice in terms of the Promotion of Administrative Justice Act, or PAJA. PAJA is the legislation that was given effect to in Section 33 of the Constitution, pertaining to fairness of administration action. Disciplinary proceedings in their nature are administrative action, and that is why this is our opinion. By referring only to the best interests of the learner, the provision in Clause 7D overemphasizes one particular interest and makes it absolute, which is not what the Constitution intends. Then about Clause 14, the amendment of Section 21 of the Schools Act, about central procurement of learning and teaching material. AfriForum is of the opinion that the proposed amendment makes provision for centrally procured learning and teaching material by the HOD. Although the proposed amendment states that the procurement is to be done in consultation with the SGB, the proposed amendment is in conflict with the entire purpose and functions of the SGB as envisaged in Section 21 of the Schools Act, and in particular Section 21(1)(c). It would be more consonant with Section 21(1)(c) of the Schools Act, and should any additional provision be considered, that the amendment provides that notwithstanding the allocation of a function in terms of 21 to a SGB to purchase textbooks, education materials, or equipment for the school, the SGB may apply to the HOD for centrally procured identified learning and teaching support material. And then in the final case, about Clause 19, about the dissolution of a governing body, amending Section 25 of the Schools Act. The difficulty with the proposed amendment lies in the periods of extension afforded to the HOD, who can extend the total period of an interim governing body to a year. AfriForum submits that the underlying democratic principles of the election of a governing body should be restored as soon as possible after the dissolution of the existing body. Therefore, the period of governance by an interim body should not be longer than 3 months, within which period the election of a new governing body should take place. In all of our submissions, AfriForum reiterated our standpoint as expressed in a statement published in the media on 5 June 2022, namely that a promise that language and culture would be protected in the new dispensation was made as part of the constitutional settlement of 1994. This included the undertaking that tolerance and opportunities for the preservation and the development of Afrikaans as well as other indigenous languages would be provided. The preservation of Afrikaans as academic and scientific language was presented as an asset in the settlement, along with the emphasis on the necessity to develop the other indigenous languages. These sentiments are entrenched in Section 6 of the Constitution. Subsequently, during the 30 years of ANC government, no serious effort has been made to give effect to this constitutional mandate, to retain and develop Afrikaans as academic and scientific language, and to develop other indigenous languages too. The amendments to the South African Schools Act as contained in the Bella Bill, specifically those pertaining to the admission and language policies, as commented on above, in our opinion, amount to a calculated attack on Afrikaans education and its speakers, while offering no relief to the speakers of other indigenous languages. Should these amendments be implemented at all, it would constitute an irreparable, unilateral and permanent breach by the government of the constitutional settlement reached in 1994. With all of the above in mind, AfriForum appeals to the National Councils of Provinces and to this committee to reject the Bella Bill and encourage the creation of a modern, fair, democratic and constitutionally sound amendment to the Schools Act of 1996. Bodies that have dealt with Bella before you have not had the moral courage to say no to the Bella Bill. I appeal to you to do so, because our children deserve better. I thank you.
Yeah, I was muted. Thank you very much, Ms. Bailey. Honorable members, I think what we should do, because we cannot engage with the presentation, like, it will take much longer time. I suggest that we ask points of clarity, and then from there, the committee are going to have enough time to engage at a later stage with some of the things, with the matters, these important matters that were raised by the representative of the AfriForum. That we only take points of clarity. Are there any points of clarity seeking questions that members would like to ask? And in the absence of that, like I said, that we are going to have enough time as members of the committee to engage with this presentation. May I now hand over to, and thank you very much, Ms. Bailey, and then give this opportunity to the Independent Schools Association of Southern Africa, ISASA, as represented by Retsepo Motsepe. Tate Motsepe, your 30 minutes.
Good morning, Chair, and thank you very much for the invite. I don't know if you can hear me. Okay.
We do, but there's an echo. There's an echo on your. Just continue. Try again. Remotsepe was muted. Can somebody help Ntate Motsepe? He sounds muted. I think he's muted.
Perfect. Thank you.
That's better. Yeah, you were muted. I think you muted yourself accidentally.
No, we don't have the rights to unmute ourselves, Chair. So the host is the one that's supposed to unmute us.
All right. Sorry about that. It's just start from the beginning.
Okay. No. Thank you very much, Chair, and thank you to members of the committee for the invitation. I'm with the Executive Director of ISASA. Together we'll be doing this presentation on behalf of the Independent Schools Association of South Africa. Chair, if it's okay, could we be allowed to share our screen for our presentation?
Yes, to share your screen, you're sharing the 30 minutes. You're
okay.
Welcome.
Thank you, Chair.
Good afternoon or morning, Chair, and members of the committee. Again, thank you very much on behalf of ISASA for giving us this opportunity. Chair, are you able to see the presentation?
Yes, we do.
Okay. Thank you very much.
Yeah. Thank you.
Thank you.
I love that.
Thank you very much. So, Chair, we will be looking at general submissions to inform you a bit about the Independent Schools Association. And then we, as an association, are going to be looking at 4 sections, Chair, for comment. It's Section 1, Section 3, Section 46, and Section 48. Obviously, this is informed by the fact that the Bella Bill primarily deals with public education, and we were just making submissions that may affect independent schools. So in the introduction, Chair, ISASA does welcome the opportunity to comment on the proposed amendments of the South African Schools Act and the Employment of Educators Act. So to align with the developments in the education landscape and to ensure that systems of learning and excellence in education are put into place in a manner which respects, protects, and promotes and fulfills the right to a basic education enshrined in sections 229, 1A and 3 of the South African Constitution. Chair, there's an estimated number of 13,409 schools and 13,491 and 971 learners, or 13 million, learners in education. Of these, only 5.5 of these learners are, only 5.5 of these learners are in independent schools. And Chair, I think that we must note that they're both registered and unregistered schools. And from our perspective, we understand that unregistered schools are not legal. Of this, Chair, we estimate that 50% of independent schools receive a state subsidy, and the other 50 are ineligible to receive a state subsidy due to their fees being outside of the equation of eligibility to be granted subsidies by the state. In terms of a grant of ISASA, Chair, we're the largest and oldest independent schools association in Southern Africa, as indicated earlier, Chair. We are a voluntary association, and our condition for membership, Chair, are three things: quality, values, and diversity. But more importantly, today we'll focus on quality, because all our schools must be quality assured to meet the minimum standards as required in Section 293 of the South African Constitution. There must be of a quality that is comparable to that of a public school. But for us at ISASA, we make sure that all our schools are quality assured every 6 years. We are an advocacy for the value of independent schools. We're not an examination body, nor are we in any ways, Chair, a governing body or an inspectorate of independent schools. This, I think, will give you a big picture of who ISASA is, Chair. We have over 900 member schools in Southern Africa, of which 883 are in South Africa. But I think that it should be noted that there are other bodies also who are associations, but we are the oldest and most comprehensive and the most representative of all of them. When you look at independent schools, Chair, for the portfolio committee, I think it's interesting to note that what we talk about is the nodes of prosperity that are in the country. Obviously, Gauteng being the largest economy in South Africa and one of the largest on the African continent, has the most independent schools, followed by KwaZulu-Natal and then the Western Cape. And then obviously the other provinces have fewer independent schools. Chair, in terms of our submissions, ISASA submissions is not exhaustive of all the issues pertaining to the proposed amendments. We highlight the key concerns emerging from our experience in the independent schooling sector and our engagement with member schools on issues affecting them with regard to the South African Schools Act. We present our submission on relevant sections and provide related recommendations as indicated. In terms of definitions, Chair, corporal punishment means any deliberate act against a child that inflicts pain or physical discomfort, however light, to punish or contain the child, which includes but is not limited to hitting, smacking, slapping, pinching, or scratching of the hand or any object, kicking, shaking, throwing objects at, burning, scolding, biting, pulling hair, boxing, ears, pulling or pushing children, and forcing children to stay in an uncomfortable position, forced ingestion, washing children's mouths with soap, denying meals, heat, and shelter, forcing a child to do exercise, or denying or restricting a child's use of the toilet. Chair, we want to note that in terms of this definition, we must have consideration of the United Nations Committee on the Rights of the Child, which defines corporal punishment to include non-physical forms of punishment, which are also cruel and degrading, and thus incompatible with the Convention. It is recommended from ISASA's perspective, Chair, that the definition of corporal punishment is widened to include non-physical forms of punishment as defined by the UNCR that have the potential to inflict fear and or infringe upon the right of the child to human dignity. It is recommended to include subsection D as follows under the definition. Corporal punishment means any deliberate act against a child that inflicts pain, fear, or physical discomfort to punish or contain the child, which includes, but is not limited to, any other act that seeks to belittle, humiliate, threaten, induce fear, or ridicule. Chair, before we go on from this point, I think it is important for us to note that from an ISASA perspective, we have schools, as we've indicated, in other African countries. We have been very clear, Chair, even in Southern Africa, that if corporal punishment is committed in that country, our schools that are members do not inflict corporal punishment. This is a clear part of our conditions of membership. And so this is important for us to think about other forms of consider mental health as part of something that should be prohibited in the section. In terms of compulsory attendance at independent of schools, Chair, section 3 and subsection 103 says, subject to this act and any applicable provincial law, every parent must cause every learner for whom she is responsible to attend school, starting from grade R on the first school day of the year in which such learner reaches the age of 6 years, and not leaving school until the last day of the year in which such learner reaches the age of 15, or will complete grade 9, whichever occurs first, provided a learner who will turn 6 after 13th of June must start attending grade R in the following year. Chair, SASA has specifically provided that the age of admission under section 45A is as follows. Grade R is for children turning is age 4 turning 5 by June of that year, and grade 1 is for 5 turning 6 by 30th of June that year. Subsection 3.1 is at variance with provisions specifically set out for the admission age of learners at independent schools. Therefore, the proposed amendment in section 33.1 should expressly indicate that it is only applicable to public schools. To avoid any confusion regarding non-compliance resulting in undue penalties or imprisonment. Chair, there's already been a case in this case, but effectively we would like parents who are sending their children to independent schools to be able to maybe send their children to school earlier. The recommendation then, Chair, from an ISASA perspective, is to amend section 3.1 as follows. Subject to this act and any applicable provincial law, every parent must cause every learner for whom she is responsible to attend school. Learners at public schools must be permitted for admission starting from grade R on the first school day of the year in which such learner reaches the age of 6, and not leaving until the last day of the year in which such learner reaches the age of 15 years, or will complete grade 9, whichever occurs first, provided that the learner will turn 6, who will turn 6 after June 30 must start attending grade R the following year. Thank you, Chair.
Chair, I'll focus on section 36, the leasing of school premises. Chair, section 36 on the leasing of school premises to independent school. So despite subsection 1, a governing body may not, without the written approval of the member of the Executive Council, enter into any loan, lease, overdraft agreement so as to supplement the school fund without the written approval of the member of the Executive Council for any purpose. So in light of the recent administrative delays, it is hoped that this provision does not constrain a number of low-fee independent schools and/or early childhood development centers and programs from renting premises from local public schools for their school activities and/or events. Chair, our recommendation regarding this amendment is that ISASA recommends that where the request to lease the property of a public school is not denied after a certain period, then the member of the Executive Council should be deemed to have granted their approval. And further to our recommendation on lease, we propose that we insert subsection 5 and include procedural measures therein as follows. The head of the department may not take action in terms of subsection 4 unless he or she has, in writing, informed the independent school of his or her intentions to act and the reasons thereof, granted the independent school a reasonable opportunity to make representations to him or her relating to such intentions, and giving due consideration to any such representation received and inform the independent school of his or her final decision in writing.
Chair, the registration of independent schools. Under section 46(4), any person who contravenes subsection 1 is guilty of an offence and liable upon conviction to a fine, to imprisonment for a period of 3 years, not exceeding 12 months, or to both a fine and such imprisonment. The introduction, Chair, of harsher sentences for non-registration of independent schools is concerning, despite the number of growing low-fee independent schools being established in support of quality education, of a standard comparable to that of a public school, in an effort to ensure children's attainment of the constitutional enshrined right to a basic education. It is important to note, Chair, that a condition of membership to ISASA is the registration of schools with the Provincial Education Department. So we really require no member school can join us if they're not registered, Chair. However, this should not be ignorant of the burden or regulatory burden requirements that form part of the registration process. Chair, the registration approvals require substantial monetary output by various stakeholders, which involve delays in obtaining mandatory clearance certificates for final registration. Here, Chair, so often a school may have most of the requirements of registration, including fire certificates, but they may be missing another certificate and therefore are not able to fully register. However, they've got most of the requirements and that ensure that the children are safe. The finding of a conviction of guilt should afford independent schools a procedural process and an opportunity to make submissions and representation of the process of obtaining final registration prior to such findings being made by the HOD. So the recommendation, Chair, under subsection 5 would include procedural measures therein as follows. The head of department may not take action in terms of subsection 4 unless he or she has, in writing, informed the independent school of his or her intention to act and reasons thereof, granting the independent school a reasonable opportunity to make representations to him or her relating to such intention and give due consideration to any such representation received and inform the independent school of his or her final decision in writing.
Okay. Chair, we now turn our attention to section 48, the granting of subsidies to independent schools. Section 48 focuses on the conditions of eligibility. Section 48, subsection 2, the member of the Executive Council may, out of funds appropriated by the provincial legislature for that purpose, grant a subsidy to independent schools subject to conditions determined by the member of the Executive Council. Now, section 48, in terms of granting of subsidies, states that subsection 48(1) indicates that the minister may, by notice in the Government Gazette, determine norms and standards for granting subsidies to independent schools. The minister has determined these norms and standards through the Amendment National Norms and Standards for School Funding. The NSF provides uniform conditions for eligibility of subsidies in clauses 176 and 177. It is important to note section 174 of the norms and standards for school funding clauses provides that the national norms apply uniformly in all provinces. And that is quite a very important statement. However, a provincial MEC may vary them so long as their spirit and intent is maintained. The head of department must consult the national DOE on this matter should there be a need to deviate from this eligibility. So in terms of the conditions of eligibility, the insertion of the proposed amendments in the Bella Bill undermines the spirit of uniformity in the application of the national norms of school funding across provincial education departments. For the education members of the Executive Committee to determine conditions over and above those determined by the Minister in the norms and standards for school funding, this creates regulatory uncertainty and may prejudice subsidized independent schools in different provinces. Since the promulgation of the NSSF, certain PEDs have and others have not complied with the uniform conditions of eligibility, despite that these exist. And this has been a struggle that many subsidized independent schools face. Despite ISASA's best efforts to monitor subsidies granted to provinces, we have found that provinces are unwilling to share information pertaining to subsidy allocations and indicative figures for the upcoming year. This has prevented certainty for schools and a lack of transparency for their successful management and operations. And this is quite a key important submission, I think, on our part, Chair, because majority of subsidized independent schools offer education that is comparable to that of a public school in areas where public schools are not accessible or have not been provided, and where the population has increased over a number of years. Therefore, the joint relationship between that school and the provincial education department through the subsidy is quite important to make sure that children receive the education that they deserve. So Section 48 further placing the responsibility of the education member of the Executive Council to determine conditions for subsidy payment will disadvantage, in our view, subsidized independent schools that may find these schools subjected to stringent and prejudicial conduct without accountability and authority on the regulatory provisions placed on them by the provincial education departments. The proposed amendments confer unfettered powers with no corresponding checks and balances to ensure accountability against abuse. The risk will ultimately be borne by marginalized learners. Therefore, we recommend, Chair, that the phrase subject to conditions determined by the member of the Executive Council not be inserted into Section 48(2) of the Bella Bill. Our further recommendation is to have subsidized independent schools report once a year and to be linked to the submission of the audited or examined annual financial statements referred to subsection 6B in proposed for amendment. This is by no means an effort to evade accountability by subsidized schools, but rather to create a platform to ensure that such accounting practices ease the administration burden in accordance with the norms and standards for school funding.
In conclusion, Honorable Chair, while ISASA is encouraged by the rationale and the spirit of the amendments to the education laws and policies, we are also concerned regarding the added layers of regulation to the independent schooling sector may infringe on the rights of learners to a quality basic education. We believe that these should be uniform and transparent and ensure that teaching and learning continues without overburdening the administration on operational requirements of independent schools. Thank you.
Yeah, Rana.
Chair? My apologies. I think we've lost Chair. Can I kindly request that one of the honorable members take over?
Morning, members. Chair Tando.
I think we've lost Chair Honorable Ndongeni. Can you please take over in the meantime?
Okay. The presenter will finish. Hello.
Yes, the presenter is finished, Chair Honorable Ndongeni. The next one to present is SAOU, Mr. Chris Klopper.
Mr. Chris Klopper, ne? Morning, members, morning, colleagues, morning, presenters. Can you please, Mr. Klopper, do your presentation? I'm sorry about that. There's a glitches in our network. But Mr. Klopper?
I must be unmuted.
Oh, okay. Sorry for that.
Thank you.
Okay.
Thank you, Matt.
All right. Your 30 minutes is starting from now.
Thank you, Madam Chair. Thank you for the opportunity to make a submission to the Select Committee. As you are aware, the SAOU is the National Teachers Union. We represent about 42,000 members, and our members render their services in 4,400 schools in all 9 provinces in South Africa. Thank you for the opportunity once again to make this particular submission. Just a moment, let me just get my... As I intimated, Madam Chair, thank you for the opportunity to submit comment. We reaffirm our commitment to the advancement of quality public basic education, and we have done so since 1996, when we participated in the writing of the SA Schools Act. It is important to note, Madam Chair and honourable members, that the current formulation of the SA Schools Act was preceded by the white paper. And that was the white paper on education that we all participated in writing, in the period since 1992 up until 1996. It was also preceded by the Hunter Commission, and everyone came to the conclusion that the SA Schools Act must be based on a cooperative partnership basis, and that implies that it is on 3 levels: the national level, the provincial level, and the school level. And it's almost, like a 3-legged pot that requires 3 legs to stand. And as we all know, that if one of those legs disappear, then the efficacy of the pot just disappears. So our comment is throughout this particular presentation based on the principle of partnership and cooperative governance. Madam Chair, I think it is important to note that we are not opposed to all the proposed amendments. There are many in Bella that we can subscribe to, that we can support, and we think are absolutely necessary. And when we express views that can be regarded as contrary to those expressed in the bill, it should not be seen as an attempt to be obstructive. It is a genuine attempt to make sure that the question of partnership and the pursuit of public education is adhered to. But however, Madam Chair, what is evident is that the drafters of Bella do not regard SGBs, school governing bodies, as a worthy partner in the principle of a public school. And we believe that a public school is a democratic extension of the community, and that the way that Bella is now formulated, that particular, as I intimated earlier, that principle of the 3-legged pot, of the national department, the provincial department, and the school is now under serious threat. There is now only one dominant role player, Madam Chair, and that is the state. Therefore, Madam Chair, and I think it is important that this particular select committee, when you go back to the National Council of Provinces, that one of the points that need to be debated is If the state wishes to retain SGBs as a valuable and trusted partner, as that almost unmissable third leg of that pot that I referred to. And then the other one is, does the state wish to revert to a state school model, or does it wish to retain a public school model? And the public school model is where the parents and the community decide what is best for the school, and not an official in a district office. And Madam Chair, I participated in the initial debates in 1996. And at that stage, the chairperson of the portfolio committee was Dr. Bladen Zimandi. And you can go and check the Hansard records. He stated at that stage that never again will the state be the primary role player in schools, and that schools must be democratic institutions. And unfortunately, Madam Chair, that does not seem to bear evidence in the latest version of Bella. The question that arises is, what are we opposed to? First of all, as I intimated, we're not opposed to everything. There are three issues that we think require further thought. The first one is admission policy, Section 5, then Section 6, language policy, and then Section 16 that deals with centralized procurement. But we want to unequivocally record our position that we say that at no stage whatsoever must there be any evidence of unfair discrimination on the basis of race, gender, or any other arbitrary ground. And then we also support the principle that all public school facilities must be utilized fairly and educationally accountable. And I think that is something that we also need to bear in mind throughout this particular discussion, and also the debate henceforth in the National Council of Provinces. If we look at Section 5, Madam Chair, the following. What is our source of serious concern? Our source is subsection 5 of Section 5, where it is stated that the final authority lies with the HOD, and we do not support that, Madam Chair. We state, trust the community to deal with this particular matter in terms of their fiduciary duties towards the community. And our proposal is, Madam Chair, that the current formulation as it is stated in Bella be retained. Why do we say that? As I stated, it is not based on the principle of cooperative governance, but the reality is, Madam Chair, it is not the HOD that will take that particular decision. He or she will not be the final authority. It will be the local district office that will exercise that. And with all due respect, Madam Chair, we cannot expect the district officer to weigh and balance all the constitutional principles. If we look at the constitutionality of the current Section 5, it has been weighed against Section 29(2) of the Constitution, and that has been weighed repeatedly. With regard to admission, it was weighed in the court case of the MEC for Gauteng versus the governing body of Rivonia in 2013. And there it is stated unequivocally that the proposed formulation complies with the principles of Section 29(2), and that there is no necessity, to give an unnecessary veto power to the HOD. We think if you do that, if you continue with the current formulation of Bella and the proposed amendments, it will inevitably lead to formal constitutional contestation. And Madam Chair, we all know that it is not in the best interest of education if education partners litigate against each other. There are only losers in such a case. The other important issue that you need to bear in mind, Madam Chair, is that there are 24,000 public schools, and that each and every year, all 24,000 public schools will have to submit their admission policy. And we can say for certain, if the decision lies with the department and they take decisions that are not aligned with the wishes of a particular community, it will definitely lead to formal review processes. So, Madam Chair, as I intimated, it is not in the interest of education to lead or to accept an amendment that will lead to litigation amongst the education partners. As I stated earlier, the question of numerical realities, you cannot review and study the admission policies of 24,000 public schools. And if it is done selectively, it will fall foul of the principles related to a just administrative decision, which at all times must be rational, it must be fair, and it must be exercised for the intention that it should be exercised for. I'd like to move on, Madam Chair, to Section 6. The proposed amendment to Section 6 that deals with language policy, it is also not supported. And there are specific subsections that I'd like to lift out. The first one is that the SGB must submit the language policy to the HOD. Now that per se, or on its own, does not necessarily, lead to contestation. But if you read further, Madam Chair, you must read this in conjunction with each other. Section 6.6 says that the HOD may approve the language policy or any amendment thereof and may return it to the governing body with such recommendations. And Madam Chair, such recommendations are normally not recommendations. They are instructions. And I'll go further and I'll come back to this particular matter again. But then there's another one. Section 6.13, which is almost unencumbered with any proposed processes, where the HOD may direct a public school to adopt more than one language of instruction. Now, Madam Chair, the wording is to direct a public school. It's not to request or make a recommendation. It is to give a direct instruction. And Madam Chair, as I alluded to earlier, that in reality, it will not be HOD. It will be the local district office that will make that particular decision and give that instruction. And there lies a huge bone of contention just on that particular level there. In regard to the constitutionality, the provision that the SGB may determine the language policy as is stated in Section 6.2, it is rendered irrelevant now by the provisions of subsection 5, 6, and 13. So it is nothing more than lip service that is provided in Section 2 to the principle that the SGB may determine the policy. So once again, Madam Chair, our proposal is please retain the current Section 6. The current Section 6 has passed constitutional scrutiny, and any provision of more powers is superfluous. And why do I say that? In the Ermelo case, the Constitutional Court has dealt with the interpretation of the current formulation of Section 6. It has dealt with it in terms of Section 29.2 of the Bill of Fundamental Rights. And in the Ermelo case, there are clear guidelines on how to deal with it. And Madam Chair, there's always the perception that language may be used as a barrier to exclude people or a barrier to commit one or other form of discrimination. And we want to place on record, Madam Chair, if there are evidences of any such abuse of powers by SGBs, please inform us. We will immediately, make work of it. But we can't find any evidence of such a discrimination taking place. So again, it's the question of superfluous powers bestowed on the Department of Education. I refer again to the question of numerical reality and the fact that you can't do it selectively on an annual basis. So the plea is, Madam Chair, let's avoid litigation because the veto power provided to the HOD unnecessarily opens the door for constitutional contestation. And as I intimated earlier, it is not in our best interest, to fight amongst each other. Section 16, it's part of Section 21, is the question of of central procurement. Now, superficially, it seems acceptable, but it truly opens the door for tenderpreneurs. And our history of the centralized procurement and all the mischief that took place during 2020 and 2021 with regard to the procurement of PPEs, all the red lights are flashing. The bill makes provision for a procurement process in consultation with the SGB. But the practice is, and we know of secondary schools where wax crayons and guitars were just delivered at the school as so-called LTSM, and it wasn't wanted by the particular school. And then it is deducted from the quantum that they must be, that is available to them to procure LTSM. So, Madam Chair, the principle of central procurement, please look at that very, very carefully. This question of school discipline is another matter that I'd just like to raise quickly. We agree with the principle relating to the prohibition of corporal punishment. We as a union, we don't want it back in any way, in any form whatsoever. But Madam Chair, not enough is done in regard to the rights of educators. And if you listen to the statistics last week with regard to the level of violence in schools, which is a symptom of ill discipline, not enough is being done in regard to the rights of educators. And then, Madam Chair, most importantly, the silent majority of learners in the school, their rights are subjudicated in terms of the rights of perpetrators who are guilty of serious misconduct. Those perpetrators get all the rights with regard to process and hearings and everything that deals with that. But the silent majority suffers in the process. So, Madam Chair, that is something that we need to look at. The last point we would like to raise, Madam Chair, is that the current governance model of schools, Section 20 and 21, has been in existence for 26 years. In the interim, time has moved on. And there is a huge need for greater autonomy to well-functioning schools. And please consider something like a Section 21A that can make provision for well-functioning schools, public schools, who have a clean audit, who comply with minimum academic performance, who comply with financial requirements, that they be given better and more autonomy. And why do I say that, Madam Chair? The best functioning public schools are comparable to the best independent schools. And it is our duty and your duty to ensure that we retain the best possible schools in South Africa in the public school sector. Thank you, Madam Chair.
Oh yeah, thank you very much. I'm now unmuted. Thank you very much, Dr. Sonebul. Honorable members, that's the presentation. Are there issues, matters that needs clarity? Am I audible? I was just thinking.
Yes, you are audible, Chair.
Yes, if there are matters, point of clarity seeking questions. Are there any such questions from members? In the absence of any, thank you very much, Dr. Swanepoel. What we'll do, we're going to have enough time as members to engage with the presentations, and all organizations will definitely get feedback, because the engagements will be open engagements of the community. Thank you very much. Let's call now concerned young people of South Africa. as represented by Dr. Elfrida Fleischmann. Over to you, Doctor.
Good morning, Honourable Chair and Honourable members of the committee. Our apologies for a change that was submitted to the program. Unfortunately, Dr. Fleischmann wouldn't be presenting this morning. It would be Mrs. Jenny Christmas and myself, Adam Mickelborough, on behalf of SIPSA. We thank you very much for the opportunity to make our representations to the committee and to the Honourable Chair this morning. We would ask if we could please also share our screen so that we can share our presentation with the committee. So we just ask if we could please share our screen. Okay. Apologies, there does seem to be a problem on our side with presenting, so perhaps we could just continue for the sake of time.
Yes, you can share now, sir.
Okay, I just need to share. Share screen. Okay, thank you. I see it is coming through now. Okay, thank you. Sorry for the delay. So we'd just like to start with a brief introduction of the organization. So SIPSA, the Concerned Young People of South Africa, is also a national non-profit and public benefit organization. We represent primarily youth and grassroots communities in all 9 provinces. And we do also provide support services to educators and learners nationally. To date, we've, as part of campaigns, we've motivated over 1 million learners. And we do also conduct several other activities on a national scale in the carrying out of our activities. So we would just like to start by highlighting our overall concerns, just a summary with the bill itself. We are concerned about the effects that the bill will have on the education system itself. We have a concern about the centralization of powers and decision-making processes which will be taken away from the SGBs. We also have a concern that at least a few provisions of the bill have the potential to violate the best interests of the child principle, which is enshrined in South African law, but also international instruments to which we are signatories. And we are concerned about the extent to which the bill erodes parental authority and decision-making, and also erodes the powers of parents to make decisions in the best interests of their child. In fact, in a few cases, there are provisions that would seem to even border on conflicting with rights enshrined in the Constitution. And we have a concern, as we would highlight later on, about some of the procedures and processes surrounding the bill, the introduction of the bill, which we believe to some extent were flawed as well. Of primary concern is the children. Our concern is that often in discussions such as this, we can forget the end user, so to say, because all of these legislating activities will actually filter down in the end to the learners themselves. And as we are both parents, it's of concern to us what the effect will be of this legislation, not only on our children, but South African youth as a whole. The first provision we'd like to just touch on briefly is the consideration of introducing mandatory grade R. We understand that there is an academic benefit to introducing children to education at a younger age. However, there are estimates that to implement grade R nationally could amount to a cost of 12 billion rand. So it's unclear to us where these funds will come from in an already struggling education system where there's a lack of facilities in good repair, textbook, stationery, safe ablution facilities, and some of the programs run, such as national school nutrition programs and learner transport programs, are already ailing. We also have a concern as to what they'll be taught if they're brought into the education system at a younger age. So we would consider that existing barriers to the constitutional right of children to a quality education should perhaps first be addressed using this funding before we consider implementing any new measures to education. The definition of home education itself, we feel, needs to be expanded. It mentions parents. We think it should be clear that this can include grandparents, relatives, guardians, and caregivers. The opportunity to homeschool shouldn't be denied on a technicality, because it seems at the moment that it refers very specifically to biological parents who would be homeschooling. And we also feel that there should be a clear and concise definition of homeschooling itself, which must be defined in consultation with the homeschooling sector.
Thank you so much, Chair, that I can also come in here. My concern is about the 12-month prison sentence caused, from non-attendance of the children. Now, as a parent, it troubles me that maybe there are certain things that I wouldn't want my child to be exposed to, but and I would keep my child at home. And one of those things being, regarding the reason I wouldn't want it is because of religious or moral objections to the content of the curriculum. Example, the CSE. It is not in my belief that that would be appropriate for my child or my grandchild to be attending a class like that. But if I am to keep my child away from that particular class, then does that really mean that I'm going to be sentenced to prison or have to pay a fine? I think there we have to make some clear, it must be clear, and that for moral decisions or religious beliefs, I can object to my child going. As we have noticed, there are many certain things that are happening which are quite frightening for us as parents and grandparents to note. For instance, these days we have this gender swap days, which is we're seeing as happening in many different places. Now, if I do not want my child, or parents don't want their child to attend this, does this mean it would, if it's a compulsory thing, that we have no say, and then there would be a prison sentence? I think we need to address that. There must be specifically included an exception where parents cause non-attendance for religious or moral reasons. It must be stated specifically. Then, if we look at some of the other things I would like to look at is that we make sure that it sounds there that it's only parents, it's speaking to parents, but what about if we have, it should include grandparents, caregivers, relatives, and others in whose care the child is. At the moment, the bill only mentions parents. Otherwise, these relatives, if they also feel the way you as a parent feel and keep the child away from school because of the things that are being taught, or for any particular thing that we find is unsuitable for our child, I think this year we must be able to object to it. We must be able to not take our children. So there has to be an exception and I feel there's no exception included, and we need to have that clarified. And make sure that grandparents, relatives, guardian or caregivers in whose care the child is and can have a conscientious objection and should be allowed in this scenario also for the previous provisions refer only to parents, and the result of this 2B and the result of, so you must excuse me, I don't see that well, would be that no one other than a biological parent could object to attendance of a class or classes on the grounds detailed above. Thank you.
So a further concern is the centralized admissions policy, which has provided centralization of authorizing admissions policy, which equals centralized control. The bill seeks to centralize this competency with HODs. Such centralization and a provision that the admission policies must be in line with the Constitution, which is admirable. But this gives the impression of an attempt to bring all admission policies at all schools in line with a single centrally dictated and enforced Constitution, which is very similar to recent proposed amendments to the Computer Bill, where it would take away the right of individual schools to determine a constitution that suits them based on inputs from parents and community members and via the SGB. So a centralized code of conduct would create a scenario where, for example, and as was mentioned by other stakeholders, where the exemption clause, where learners can be exempted from requirements of a code of conduct, can create a scenario where, for example, a learner wishes to attend a Christian school or a school of another religious belief, but wishes to adhere to a lifestyle or religion not in line with the ethos of that school, and where the school may then be compelled to allow them to do so. But basically, the primary concern here is that there seems to be a move towards a centrally dictated and enforced code of conduct for all schools.
Yeah. The withdrawal of SGB functions and powers is another concern we as parents have, because who knows the child better than the community, than the parents of that child? So I would suggest that there something else is done. The bill creates a significant withdrawal of the functions of governing bodies and ultimate places these functions and decision-making powers in the hands of provincial heads of department. However, school SGBs are usually made up of parents, traditional leaders, local leaders, and businessmen and community members with knowledge of the community, its members and the learners attending their school themselves, who are therefore best equipped to make decisions in relation to the running of the school and the well-being of their learners. So I feel here, myself and many parents, we strongly object to the withdrawal of SGB functions and lessening of their powers.
An area of quite a lot of concern, as was also seen at the public participation events, is the effect that the bill would have on home education and the home education sector specifically. And here we feel that there is a potential to violate the best interests of the child principle. And we also see that parental rights would be eroded by these provisions. The first challenge that would be faced by homeschoolers is additional burdens, financial burdens, and other requirements to be met in order to register for homeschooling and to be approved for homeschooling. It was indicated at public participation events that the focus on homeschooling is to ensure that no homeschooled learner slips through the cracks, which is admirable, but we struggle to understand why such a focus on homeschooling when the education system itself is currently failing in many cases, and a very large proportion of learners who enter grade 8 fail to progress through to matric, and where many schools are unsafe for learners and teachers alike. So where you have a very small homeschooling sector, we struggle to understand why the focus is on homeschooling and not on these already highlighted issues within the South African education system. Of most importance, an official should not be able to override a parent's decision to homeschool, and it should not be necessary for a parent to apply for permission from the state to homeschool their child should they wish to do so. Under no circumstances can the department or any official determine whether homeschooling is in the best interests of the child as provided for in the bill. It's parents who know their child best, and it is parents that must make this determination. It is also a fundamental principle of international education law that the parent has a prior right to choose the kind of education a child receives, and the bill makes significant inroads into that right and practically then seeks to undermine parental authority. If you look at the best interests of the child as mentioned in the Children's Act, the parents' responsibility is to protect those children and to make decisions in their best interests, thereby ensuring the best interests of the child in all considerations. As it has been said, a government has never given birth to any child. Should a parent be unable to comply with the requirements for homeschooling their child will be forced to enter the mainstream education system, which is currently characterized by an overall lack of resources, rampant drug and alcohol abuse, poor teacher-to-learner ratios, violence and intimidation, teenage pregnancy, theft and sexual assault perpetrated by learners and even teachers, a high failure and dropout rates, as well as exposure to an imported sexually explicit CSE curriculum. So for us, it's unclear how it can be alleged that to remove a learner from one-on-one tuition in a safe environment and under the supervision of a child's parent or primary caregiver, and then to subject them to these conditions when they have the opportunity to be homeschooled, can in any circumstance be said to be in the best interest of the child. Here also, the minister should not have such broad scope in making regulations on home education, and should at a minimum only be able to make regulations in consultation with the homeschooling sector. It has been brought also to SIPSA's attention that the minister acknowledged during a PCBE meeting that the DBE had to date neither conducted nor did it possess any research on home education within the South African context, while the need for such research was identified as early as 2015. We're also aware that accurate and adequate research is a fundamental prerequisite for a credible socio-economic impact assessment, based on the fact that no research was included in the SEIA that was drafted together with this bill. It's our belief that the procedures followed in adopting this bill were themselves fundamentally flawed, and SIPSA believes it would be irresponsible for the bill to proceed any further without a proper evaluation of the potential impact and possible unintended consequences of this bill having been conducted. So we have concerns about procedural issues here as well. And we understand that there was research also that was completed by another organization. I believe they themselves will present, and was submitted to the DBE but was not included. So we have a serious concern about the lack of engagement with the homeschooling sector in South Africa and the organizations representing the homeschooling sector in South Africa. Another concern we have is that the bill provides for the closure and merging of small schools.
And that is a very grave concern to us, because many children in the rural areas already are walking distances to get to the school. But now if that small school is a small school, then they close it. How much further are the children going to work? And especially in this climate of South Africa, where children are being what's it, Adam? Where the children are
human trafficking.
Yes, human trafficking is so, you know, it's so full in our country. What is going to become of these children? So that is a concern to us. Why should they close these schools, the small schools? Because very often from these small schools comes the best education, because the schools are not so, the classes are not so full. But if they're going to push the children into other schools which are already overloaded, what is the outcome going to be? So there as well, with that, the department has such power, we object to that for the sake of the children, that they are able to still remain close to home and are able to go to a school that's closer to home than to walk the distances.
So we also here as an organization have witnessed situations where female learners are actually staying alone in rented accommodation near to schools because of the need to travel great distances to attend school. We also have a concern that by closing a small school, there can lead to an increase in the distance that learners must travel, an increase of the cost of transport for parents, and in some cases, it may simply result in non-attendance because children will have greater distances to travel to school. So again, we would have a concern about whether these provisions are in the best interests of the child, because you will again be taking learners from micro schools, if we can call them that often are, even if not well resourced, produce good results, in some cases excellent results, because there's a good learner to teacher ratio. If we close these smaller schools, we will again be forcing children into the mainstream school system, where we've already outlined many of the shortcomings there. And it cannot be said, we believe, in any circumstance to be in the best interest of a child to remove them from a safe and well-controlled and organized and successful schooling environment and force them into that mainstream education system, taking away that opportunity of theirs to have a quality basic education as enshrined in the Constitution. Here we also have a concern, reading between the lines, where there's mention made of a central committee who will decide on curriculum matters and which will provide for a centralized procurement of identified learning and teaching support materials for schools. So our question as parents is, who will sit on this committee? What are their values, beliefs, and worldviews? And how will this influence the identification of suitable materials, which will then be disseminated centrally to all learners within the education system? So one thinks of the newish CSE curriculum, which we've imported from overseas, and which contains sexually explicit themes and content, which is in actual fact foreign to South African cultural norms. And it is our belief that SGBs, in consultation with parents, must identify suitable teaching materials for their children.
At this point, I'd like to emphasize that because, like I said, when in the school, they're going to have days which are compulsory for your child to attend because of gender swap, all these new things from the woke agenda that my child is it's foreign to my child, but now we have to fall into this. So I strongly, this is my personal opinion, I strongly object to the centralized procurement of study materials. I believe we as the SGPs, parents, and we need to be consulted, and we need to identify suitable teaching materials.
Language policy, we have similar concerns to some of those which have been raised by other organizations and stakeholders that have spoken today. Disempowering SGBs from determining a school's language policy could be exploited to target single language and mother tongue education schools, such as Afrikaans medium schools. We also feel, as with the other central authorization of other policies, admissions policies, and disciplinary code of conduct, it's impractical for HODs at provincial level to improve language policies and other policies of all of the schools within that province within the required time frame. The bill provides that where it is determined by the department that a school must adopt an additional language, adequate resources for the successful adoption and implementation of the additional language must be provided. Again, it is unclear where these additional resources will be acquired within an educational system that already suffers from a chronic lack of financial and material resources. Further, such provisions could border on a potential violation of the rights of individuals to use the language and to participate in the cultural life of their choice. These provisions are enshrined in Section 30 of the Constitution. So provisions such as this run the risk of appearing as a veiled attack on certain language and cultural groups. So here and in a few other cases, we see provisions in the bill which seem to actually even border on being in conflict with rights, constitutional rights of language and culture. So here we would like to thank the committee for the opportunity to present those concerns which are of critical importance to us. We do have others, but because of time, we've limited it to these. We trust that other stakeholders will also touch on the other points.
And I say as well, Honourable Chair, thank you for the opportunity. But again, I want to emphasize, we as parents are not supportive of the Bella Bill. We need to have we need that there's more consultation. But right now, the Bella Bill, to us, is a red flag. Thank you very much.
Thank you very much, Chair.
Yeah, thank you very much. Thank you very much, concerned young people of South Africa. Thank you for your presentation. Members, do you have clarity-seeking questions? I'll check on the screen for the so far none. Thank you very much, concerned young people of South Africa, for your presentation. We will engage with it. The time will come, and obviously it will be in the public domain when we do that. May I take this opportunity, after thanking you, to welcome the Western Cape Forum for Intellectual Disability, represented by Ms. Vanessa Yafta. Over to you, Ms. Yafta. Western Cape Forum.
Good morning, Chair.
Yes.
Good morning, Chair and committee members. Thank you for this opportunity. I'd like to share my screen with you, please. Can you see the screen?
Yes, I do. It's very colorful.
Thank you.
Yes.
Thank you. We are here to speak about the Bella Bill and the forum, as we call ourselves when we are talking. We say the WCFID in our written submissions mostly. We'd like to speak about the Bella Bill and the implications it has for children. Firstly, our focus here is on children, and I'm going to speak about children with disabilities. But these children are children first, and they have the same human rights as all children. They also have special protections granted to them by virtue of them being in need of protection. Our forum is membership-based. It includes special care centres, and I'll elaborate on what that is later. Individuals, schools, teachers, health and social work professionals, academics, researchers, etc. We focus on training, resource development, and advocacy on intellectual disability. Our interest in Billable B2 2022 is its silence on inclusive education and the education for children with disabilities, and specifically for us as Forum on Intellectual Disability on the right to education of learners with severe to profound intellectual disability. We draw the committee's attention to Section 3 and its amendment, subsection 6. Any other person who, without just cause, prevents a learner who is subject to compulsory attendance from attending school is guilty of an offence and is liable on conviction to a fine or to imprisonment for a period not exceeding 12 months, or to both a fine and imprisonment. What the committee may not be aware about is that there's a vast number of children with disabilities who are shut out of the education system. We call this silent exclusion. And I think the Billable, as it now stands, demonstrates this silent exclusion. The bill is silent on the systemic exclusion of learners with disabilities from public schools, and especially those who attend special care centres for learners with disabilities. These are NPOs. In its current form, it perpetuates and entrenches the practice of progressive access to basic education for children with disabilities, rather than the immediate positive right enshrined in the Constitution. Sections of the bill conceal the systemic, policy and legal gaps and practice of refusing children with disabilities at public schools or placing them on waiting lists. These sections, although directed at parents or caregivers, etc., or people who protest, certainly place reciprocal obligations on the minister and education officials. We submit that this bill, perhaps we should say possibly, exposes the minister and education officials to criminal charges for preventing a learner from attending school. And I suppose a court would clarify what prevent means, and whether systemic exclusion of children with disabilities could be described as preventing children from attending school. Perhaps to give the committee more information about the silent discrimination against children with disabilities, we should include the fact that DBE excludes an estimated 200,000 to just under 600,000 learners with disabilities from the public school system. Those were the stats in 2016. We acknowledge that DBE later reported to Parliament that this figure is much lower, and that over 90% of children with disabilities are excluded from school. Perhaps we should underline the fact that one child excluded from school on the basis of disability is unacceptable and is a violation of the Constitution. We as the Forum represent special care centres that accommodate some of these marginalised learners who have severe to profound intellectual disability. We notice too that the bill is silent about the relief ordered by the court more than 13 years ago. The court judgment was brought on the basis of Section 29 of the Constitution, the right to education. This silence creates the impression that all children have equitable access to the right to basic education. It renders children with disabilities invisible. The reality is that children with disabilities face an obscure, complex application process that leads to children being placed on waiting lists for up to 5 years, and some are never admitted to schools. So who are these special care centres and why do they exist? They exist because schools don't admit them. And they're a response from parents and other community members who have established these community-based NGOs to support the out-of-school children with SPID. Their exclusion is a contravention of the Constitution and the South African Schools Act. And the bill silence on enabling legislation further undermines the rights of these children to care, protection, dignity, equality, non-discrimination, and education. While we speak about children with SPID, we recognize that all children with disabilities who are excluded from public schools have the same constitutional right. We therefore submit that the bill is a missed opportunity to legislate and fund inclusive education and education for children with disabilities, as enshrined in the Constitution. DBE has had over 20 years since it gazetted White Paper 6 to remedy the systemic violation of the right to education for children with disabilities by promulgating legislation to promote inclusive education. The Finance and Fiscal Commission, in its report to Parliament, in its technical report 21/22, noted that the policy process is complete only once the policy is translated into legislation. A vital step is missing in the policy process, which is the translation of policy into legislation as far as inclusive education and education for children with disabilities is concerned. The FFC provided this table to indicate just how dire the situation is. So in 2001, DBE published the white paper on special needs education, building an inclusive education and training system. It then published all these guidelines, a national curriculum statement, policy on screening, identification, assessment and support. But I'd like to draw the committee's attention to this item, the draft national norms and standards for resource distribution for an inclusive education system in 2015. Yet, in 2018, DBE seemed to backtrack from making this legislation to resource inclusive education and published it instead as draft guidelines. As guidelines, policies, they have no legal effect. We'd like to speak about how this affects the children whom we represent here today. In the hierarchy of disabilities, yes, believe it or not, there's also a hierarchy of disabilities. The children with SPID fall into the disability that affects the mind and, in some cases, the body, the brain, the neurocognitive development. And it was on the basis of that disability that DBE did not provide education in any form whatsoever. And the forum therefore took the National and the Western Cape Provincial Government to court. And in 2010, the judgment concluded. It is declared that the respondents, that's National and Western Cape governments, have failed to take reasonable measures to make provision for the educational needs of severely and profoundly intellectually disabled children in the Western Cape. Please note the educational needs as in Constitution 29.1. In breach of the rights of those children to a basic education, protection from neglect or degradation, equality, and human dignity. I cannot see my full... Sorry. I couldn't see my full screen because I have too much text, so please forgive me as I go into this format. The court then ordered the respondents to give effect to the said rights of severely and profoundly disabled children, including but not limited, ensuring that they have affordable access to a basic education of an adequate quality, providing adequate funds to organizations such as to enable them to have the use of adequate facilities, hire adequate staff, provide appropriate transport, enabling the staff to receive proper accreditation, training, and remuneration. Now, DBE reports that it does not have the enabling legislation to fund these centers. And our question is, why was the bill not used as an opportunity to include such legislation? So if we were to look at the court case and who has the legal mandate for, or the primary legal mandate to respond to the court order, we submit that it is DBE. Firstly, in terms of the fact that it derives its mandate from the NEPA. It is an education system to contribute to the full personal development of each student, to achieving equitable education opportunities, redress of past inequalities. And so the South African Schools Act, NEPA, and various judgments have informed our submission that DBE is responsible for the implementation of the court order. For infrastructure, and that's the case you can refer to if you'd like to, staff remuneration of the teaching and non-teaching staff, and learner transport. So the courts have clarified that these are components of basic education and therefore DBE's legal mandate. DBE provided a conditional grant to respond to the court order. What it did was it responded broadly to the first section of the court order by providing outreach teams to centres and LTSM. They provided zero funding for infrastructure, staff remuneration, and learner transport. Although the grant in its division of revenue bill format does not speak to the training, accreditation for appropriate remuneration, the Minister, in a written reply to Parliament, reported that DBE is already collaborating with UCT. This was in 2017. Collaborating with UCT to develop this level 5 qualification for staff at the care centres. Yet almost 7 years since the Minister wrote this reply to Parliament, we have no evidence of the course. If you're interested to know how much the grant is in the MTEF, it would be 875 million rand there. Oops, sorry, don't do that. Okay. How do learners benefit from the grant? They get toolkits, that's LTSM. And in terms of support from outreach teams, that's 6 to 10 hours per quarter. So the 800 million over the MTEF will provide services to the children at the centre for 6 to 10 hours. They do not have equitable access to learner transport, teachers, appropriate facilities, adequate therapeutic services, per capita learner funding, adequate salaries for staff, or the NSNP. So the parents and the centres are carrying the costs mainly, except for some funding from DSD and DOH in the Western Cape. We are further concerned that in 2018, DBE committed at a roundtable to enhance government services for children with severe to profound intellectual disability, in which we participated. They actually committed to reviewing the legislation. So this is from DBE's website, and this screenshot is from the minutes of the roundtable. DBE committed to review the South African Schools Act and the Learner Transport Policy, to review legislation, including personnel administrative measures to include the carers at the centres, to enable DBE to fund their salaries. DBE also said that by the end of January 2019, they'd have an implementable plan, and by March 2019, they'd present it to Cabinet for final approval. That happened in 2018, so it was quite surprising to us that in 2019, DBE reported to the Portfolio Committee on Basic Education that they're unable to fund these centers or transfer funds to centers because of the absence of enabling legislation. And I'd like to oops.
You seem stuck, man. You sound stuck where I am. I can't hear your presentation.
Okay. I will close that and go back to my presentation. So I think you'd be able, as honorable members, to listen to this in your own time by simply clicking on the images. They are simply sound bites from portfolio committee meetings in which DBE reports that it lacks the legislation. And so once again, we ask, who is supposed to promulgate the legislation? Whose responsibility is it? And was the Bailiff not the opportunity to do it? It's taken a step further in the committee meeting of social development in March, where the Department of Women, Youth and Persons with Disabilities, DBE and DSD, echoed concerns that their work was proving to be limited in scope and reach due to the lack of disability legislation. And so what we are saying is, once again, why was the Bailiff Bill not the opportunity to ensure that we domesticate the UNCRPD, Article 24 on inclusive education, Constitution, Section 29.1, the right to basic education of all children in South Africa, SDG 4, which is to ensure inclusive, equitable, quality education, and the NDP goal 13, which is to ensure full access to compulsory schooling. In conclusion, the right to basic education is an immediate constitutional right, not subject to available resources. It should be prioritized for children with disabilities. The Bailiff Bill is silent about the constitutional, legal, and jurisprudential mandate of the Department of Basic Education to provide education and its components to learners with disabilities of compulsory school-going age at special care centers. The court order to provide funding to special care centers for children with SPID, the amendments that should be made to personnel, funding, and resourcing legislation to enable equitable access to education for children with disabilities in and out of public schools. The Forum concurs with the position of the Equal Education Law Centre. In the education sector, there has been a failure to comprehensively regulate inclusive education through binding legislation. This has resulted in the resourcing and provisioning of inclusive education going unchecked, unprioritized, and unfunded. We propose our recommendations are that the bill should include amendments that explicitly prohibit the exclusion of children from schools and publicly funded education based on disability. Incorporate enabling legislation that promotes and supports the funding and resourcing of equitable, inclusive, quality education, and that specifically amends current legislation to allow it to fund and resource organizations such as special care centers that are in fact trying to do DBE's work that the Constitution and the South African Schools Act demand. That it amends the funding and resource allocation to ensure learners at SECs access equitable, inclusive, quality education that includes all components of basic education, funds for infrastructure, adequate staff, learner transport, access to the NSNP, and that it amends current regulations to increase and expand the current conditional grant for the education of learners with SPID at special care centres to align with the Education Department's constitutional and legal mandate. And we strongly recommend that amendments be made in consultation with learners, parents, civil society organizations, disability rights organizations, and education rights organizations. If you'd like to know more about the submissions we've made to Parliament, please consider visiting our website, and if you click on the slide, you'll be able to access our submissions page. Thank you very much, everyone, for your attention and consideration.
Thank you very much, Mayor Vanessa Jafta. We members, if you have clarity-seeking questions, you may ask them. And in the absence of, let me check, in the absence of any clarity-seeking question, we're going to get enough time to engage as the committee with this inputs. Thank you, Western Cape Forum for Intellectual Disability, Mayor Vanessa Jafta. We're giving this opportunity to FEDSAS, as represented by Dr. H.J. Deacon and Mayor Juan van der Merwe. Over to you. You can share your 30 minutes.
Thank you. Good morning, Chairperson and members of the Select Committee. Again, thank you for the opportunity not only to submit our written presentations, but to make an oral presentation as well. I presume, and we expect, that the members by now should have worked through our comprehensive document that we've submitted. So we're not going to deal with the document and all the legal arguments per section. Instead, we're going to highlight the crucial areas in our presentation. I have a legal background, but my colleague Johanna van der Merwe, she's our Deputy CEO, but also the Head of Legal, will do the presentation, and then I'll rejoin at the moment we start to engage or discuss certain aspects. And I'd really like to invite the members of the committee to engage with us. Like the previous speaker, we also moved for inclusions. Whilst we have the opportunity to engage, let's make the legislation better through lessons that we've learned. So our presentation will consist out of that as well. I'm looking forward to actively engage. But for now, I'm going to hand over to Johanna van der Merwe.
There we go. Good morning, everyone. Chair, can I please confirm whether you can see my screen, whether it is visible on your side?
You are loud and clear, ma'am, and we can see all the colorful presentations you are giving.
Wonderful.
Yes.
Thank you. Thank you so much, Chair. From my side as well, to you, Honourable Chairperson, Mr. Nchabileng, and members of our Parliamentary Select Committee, from my side as well, on behalf of FEDSAS, I extend my greetings to you all. It's an honour to address this committee and also to contribute to the dialogue surrounding the ballot bill. And we also appreciate the opportunity to present our perspectives and insights specifically on this bill. Now, I would like to start with this first slide just to give you a brief introduction as to who we as FEDSAS are. We've been a partner in education for so many years, so we trust that that you will listen intently to our contributions today. Now, FEDSAS is the national representative organization for governing bodies. We stand as a key partner in the South African education landscape. Our organization was founded in 1993, and we have well-established structures in all 9 provinces in South Africa to serve our member schools then nationwide. Now, also in alignment with the cooperative governance model as is outlined in our constitution, FEDSAS also maintains direct contact with national and provincial education departments. We actively participate in all 9 of those provincial consultative forums. Now, the National Consultative Forum was also established in 1999, and that was established followed engagements between FEDSAS and the then Minister of Basic Education. So we also serve on that National Consultative Forum, where we very often on a quarterly basis engage with the National Department of Education as well. Now, FEDSAS supports governing bodies of over 2,000 member schools, and we serve a diverse selection of schools, including a diverse selection of languages, cultural communities, from our rural areas also to schools that is in our current cities. FEDSAS have actively participated in all 27 public hearings that was held by the Education Portfolio Committee, and up to date we have attended 36 of the additional public hearings that was conducted by the provincial legislators in all 9 provinces. We know that this is still an ongoing process, and we will be visible and taking part in the sessions that are still to come. Now, our vision at FEDSAS is to preserve and promote quality of education throughout this country. We truly believe that schools are more than just a place of learning. They are truly the beating hearts of our community, and they do shape the future of the children in our country. Now, at the core of every school's success is also its school governing body. And we know they comprise of dedicated individuals who steers the direction of the schools through their practical experience and through the policies that they assist with. Now, there's a couple of underlying principles that I wish to start with, as it is important that we need to understand these principles because they form the foundation of how our education system works. Now, just to kick this off, I'd just quickly like to give a brief overview as to how our education system and the governance model has developed over the last 30 years or so. Now, until the mid-1990s, schools in South Africa were actually characterized by a hierarchical, authoritarian structures and cultures. Recognizing this need for change, the then newly established Department of Education aimed to shift decision-making responsibilities in schools from bureaucrats to a more decentralized and collaborative structure. Now, FEDSAS was part of that process, and we strongly supported the move from state schools to public schools. That led to the enactment of the South African Schools Act, which then obviously sought to uphold the rights of learners, parents, educators, and then also to promote their involvement in school governing bodies. Now, secondly, and important, and we can never underestimate the role that parents play in the education of their children. Our South African Constitution recognizes that parents have and are the primary responsibility and have the primary responsibility for the education of their children. Parents have the right to choose the form of education that's best for their children, and that right also includes the right to choose language, cultural, or the religious foundation of the education. That right was clearly vested and is clearly instilled in White Paper 1. Now, the South African Schools Act also emphasizes the importance of parental involvement in education and also established school governing bodies as a means to facilitate that involvement. Now, our parents are represented in school governing bodies and are typically in the majority. That is to ensure that they have a significant influence on the schools they serve, on the policies that's being determined and the practices. Now, as parents play a central role in the governance of schools in South Africa, they are there to ensure that their voices are heard and that they have a say in how their children's schools are run. That reflects a broader commitment to the democratic principles and the recognition of parents as key stakeholders in our education system. Now, when we look at the third bullet on your screen, you will note that I have made a clear distinction between a differentiated society versus a totalitarian state. Now, perhaps it should be clearly emphasized that in South Africa, we have a differentiated society. And if we were to limit our parents' rights in this differentiated society, that would have significant implications. It would undermine the principles of democracy and also this participatory governance that we have been central and that have been central to the post-apartheid education reforms. By limiting parents' ability to participate in school governance, the government would be reducing the diversity of voices and perspectives that contribute to decision-making, leading to decisions that do not reflect the needs and preferences of the community that our school governing bodies and our parents serve. They will take us back to a totalitarian state where the government would seek to exert control over aspects of society, centralizing power and control. Now, I was privileged enough to conduct thorough research on cooperative governance and this model that we have in South Africa. I have just submitted my LLD thesis on this specific topic. Therefore, I'm very passionate about this cooperative governance model that we have in South Africa. This specific model envisions a partnership between the national government, provincial government, and school governing bodies. The Constitution, our South African Constitution, has also affirmed that the cooperative governance model in education is a cornerstone of our South African democracy. It emphasizes the importance of collaboration and partnership between the different levels of government and school governing bodies. Limiting the powers of school governing bodies or centralizing power in the government would contradict this cooperative governance model that we have worked towards for so many years in South Africa. And then finally, just to quickly highlight to you that there are a lot of court judgments that protect and give effect to these bills or these rights in the Bill of Rights that I have highlighted, specifically referring to the matter of Ermelo and Welcome, which emphasizes the importance of protecting and giving effect to the rights as set out in the Bill of Rights, including the rights of parents in the governance of their schools. Now, when we look at the proposed amendments, I would like to point out that it is against the backdrop of preserving the current democratic and participatory governance structures in South African schools that we must analyze the potential impact of the proposed amendments. Our view is that several proposed amendments that is set out in the Ballot Bill pose a threat to the progress of our education system reform. They also suggest an attitude that the state holds the ultimate authority over certain powers. Now, these changes centralize powers in the hands of the state and diminish parents' rights as significant stakeholders in our education system. They risk reinstating the authoritarian structures of the past which undermines the strides that was made towards a democratic governance. Now, in practical terms, this will basically take us back to a state school system. In that system, we have deliberately abandoned 30 years ago. But I will elaborate a bit on this later on in this presentation. Now, I would like to highlight this following very important matter that concerns this committee dearly and extremely. We wish to bring to the attention of the Select Committee that several submissions was made to the Portfolio Committee by Mr. James Ndlebe, who is the Direction for Education Management and Governance Development at the DBE. Mr. Ndlebe proposed that the sections in the Schools Act specifically concerning admission and language policy of public schools remain unchanged. Regrettably, these recommendations made by the DBE were not taken into consideration by the Portfolio Committee, and it is not reflected in the committee's report or the current version of the ballot that we see. It is actually very concerning that the DBE's suggestions to maintain the current provisions in the South African Schools Act regarding language and admissions was wholly ignored. It appears that this oversight was not acknowledged by the Portfolio Committee, and we therefore urge this Select Committee to investigate the submission by the Portfolio Committee. We do encourage this Select Committee to learn from the mistakes of the Portfolio Committee and heed the DBE's recommendations regarding these provisions. Now, I trust that this committee will also concur with the view that the primary goal of the Ballot Bill should be to improve the quality of education for every child in South Africa. Now, in our assessment of the Ballot Bill and its clauses, we use specific criteria, and you will see there on your screen the criteria we used in preparing our comment on the Ballot Bill was firstly to ask whether the specific proposal will improve education, whether it is in line with the spirit of the South African Schools Act or not, and then finally we considered the different shortcomings in the Ballot Bill. And the following slides, I will deal with all three of these criteria, which I will highlight to you. Now, we have expressed, when we look at the amendments or the proposed amendments that will improve education, we have expressed our support for several sections in our written submissions. In essence, we endorse those sections that will enhance education and consequently the management of education. Please refer to your screen where we have highlighted those sections that we do support that is currently proposed in the Ballot Bill. Now, when we consider the proposed amendments that will not contribute to the overall quality of education in our country, I would like to highlight some concerns because it has severe impact on the autonomy and the governance of our public schools. Therefore, I'd firstly like to refer you to Clause 4 that proposes the amendment of Section 5 of the South African Schools Act. Now, FEDSAS strongly opposes Clause 4. These amendments not only restricts a governing body's authority over a school's admissions policy, but it also infringes upon the rights of parents. The proposed provision grants the provincial HOD the final authority to admit learners, and it undermines that collaborative framework of the Act and limiting parents' involvement in decision-making regarding their children's education. We also argue that governing bodies are intimately involved in a school's operation. The governing body is best suited to determine the school's admissions policy, and they can consider factors related to planning and governance. Now, FEDSAS is also concerned about the practicality of the proposed approval process, which requires the HOD to approve the admission policy and any amendments thereto. Just given the logistical challenge faced by provinces in handling daily submissions and correspondence, this process seems impractical, especially considering the large number of public schools in South Africa. Now, we believe that the proposed amendments would hinder effective governance and decision-making at school level, and we therefore move for its complete removal, as was also recommended by Mr. James Ndlebe, from the Department of Basic Education. Now, the current section of the Act is sufficient to give effect to the constitutional right of every child in South Africa. And the HOD and MEC already have the powers to deal with any abuse in this specific regard. We would also like to submit that the only submission that should be included and given attention to should be a provision for national regulations on the determination of capacity in schools. But I will deal with that in just a moment. Now, secondly, when we consider clause 5 of the Bella Bill, this proposed amendment are also deeply concerning to us, granting the HOD the power to direct, and I put the emphasis on direct, the school governing body concerning language policy also raises concerns similar to those regarding the HOD having the final authority to approve the admission policy. Once again, this indicates a shift towards an authoritarian state and a reluctance to uphold the values as is set out in our South African Constitution. We therefore also reject the whole clause 5 as is proposed in the Bella Bill. Now, with the extensive powers to add additional languages, schools will become parallel medium schools, and the current post-provisioning and funding models in South Africa does not adequately address the challenges of multilingual education in South Africa. We've also not seen any costing in this regard and submit that the National Council of Provinces should get this information before making any decision in this regard. The reality is that provinces will have to foot the costing and the expenses that this bill will eventually result in. Now, when we look at the actual challenges and issues, or rather let me call it opportunities relating to admissions, we have experienced over the years that we have been involved in education that most of the admission disputes between governing bodies and provincial education departments do not involve a school's language or admissions policies. These conflicts often arise when schools are asked to admit more students than they can accommodate, and that is usually due to financial, administrative, or physical space limitations. The key is therefore in determining whether a school has the capacity to accept additional learners. Now, to address this challenge, we believe that there must be clear guidelines which aligns with the minimum uniform norms and standards for public schools that will assist with and give guidance to the determination of a school's capacity. We therefore propose establishing objective criteria through national regulations, and this can then guide our school governing bodies and our education departments. Now, going to the third bullet on your screen, considering the proposed amendments to Section 21, that's the central procurement proposal. We feel that this will bypass the allocation of the function of the governing body under the Schools Act, and this will potentially allow the HOD to revoke school governing bodies' functions without due process. We have concerns about the department's capacity to effectively procure quality materials, given the past challenges in their timely deliveries as well. Now, also until we as a country have adequately dealt with corruption, central procurement will result in losses for the sector and will not be in the best interest of our children in South Africa. We therefore also propose that this amendment should be removed unless it allows schools to voluntarily opt in to this procurement method. Looking at the proposed amendments to Section 43 and 48, requiring governing bodies to submit quarterly reports in addition to their annual audited financial statements would impose a significant financial and administrative burden on both the governing body and the school's resources. Now, this proposed clause does not come with any extra funding or staffing for our schools. If this is to be retained, the provision should be tailored to situations where compelling reasons exist for such reports. It is important to note that schools already submit annual audited financial statements every year. So if this clause were to apply exclusively to schools that did not submit their audited financial statements the previous year, or to schools that did receive qualified audits, then the acceptance of this clause would be warranted. We therefore propose that regulations should be developed to deal with those schools and the processes that must be followed to correct the position and the status of the school. And then finally, when we look at provincial capacity, FEDSAS has written and we have requested comprehensive costing analysis from the Select Committee and from the provincial legislators regarding the affordability and the viability of implementing the changes proposed by BALOP. However, we have not, unfortunately, received any reply in this regard. It is emphasized that an analysis should be conducted before a decision is being made on the feasibility of approving the proposed amendments. This analysis should cover funding for making grade R compulsory. Audits must be done to look at the available spaces and infrastructure for grade 8. We must also consider and evaluate the availability of qualified educators for grade R and for parallel medium schools. And then finally, the funding to introduce parallel or double medium schools in South Africa because this is where the BALOP bill would eventually lead to. We highlight that the current funding and the post-provisioning models in South Africa do not account for these aspects, and implementing them would be more expensive than our single medium model, which would ultimately impact on the provincial budgets. Then I would like to conclude with this final slide. When we look at the shortcomings and our proposals in this regard, in response to the challenges that was posed by the COVID-19 pandemic, we feel that a clear definition of meetings is suggested. This will address any and all uncertainties regarding and surrounding online gatherings. I have already touched on and dealt with our proposals regarding a blended learning and the regulations of determinations of capacities. When we look at the third bullet, the national and provincial consultative forums for school governing body associations, we feel that to ensure meaningful dialogue, the establishment of a formal statutory structure for national and provincial governing body organizations is recommended. The minister would be responsible for issuing these regulations governing the operations of these forums. Now, we know that unions have the ERRC, but our school governing bodies must rely on agreements. Surely this is not the message that we want to share to the different partners in education. We feel strongly that it should be the minister that determines the financial directions, and therefore we recommend that section 37(1) must be amended in this regard. Then finally, when we look at conflicts that can arise, specifically when there are conflicts between national and provincial legislation, we feel and we propose that a provision must be incorporated into the South African Schools Act, giving precedence to national legislation in cases of conflict and ensuring uniform application of the South African Schools Act. We have already seen, and there are ample examples of this in our Labour Relations Act and legislation. So I would like to conclude with saying that as FEDSAS, we remain dedicated to advancing quality education and democratic governance in our South African schools. Now, while the bill has some positive aspects, they are overshadowed by the 4 points highlighted in this presentation, which would hinder rather than enhance the quality of education in our country. As a key education partner, FEDSAS advocates for maintaining school governing body autonomy and promoting cooperative governance involving all stakeholders, particularly our parents. So we oppose the BALOP bill amendments that centralize power, reduce parental involvement, and undermine the progress in our democratic governance in education. Few of the proposed amendments address the actual problems in education. So we therefore urge the Select Committee to consider our submissions carefully and collaborate to ensure that any changes to the South African Schools Act uphold democratic, inclusive, and excellent education principles.
Thank you, Chair. That's our submission. We'll gladly take questions for clarity and engage with you specifically on the proposals that we feel should be included, that we don't miss the opportunity to enhance the quality of education. So you would have seen that we support some of the clauses. We raised serious concerns about some of the clauses, but also moved for the inclusion of a number of items. Thank you for the opportunity.
Thanks, FEDSAS, for your oral presentation. Thank you very much, Dr. Dicken and Mayor Juan van der Merwe. Members, if we have clarity-seeking questions, you may raise your hand to engage with them now. But anyway, we're going to have enough time to engage as a committee with these presentations. And I'm trying to go to check my, see any, yeah, okay. In the absence of any clarity-seeking question, thank you very much, Dr. Dicken and Mayor van der Merwe, for your...
Chair?
Hello?
Honorable Christian's hand is up.
Oh, let me just check if... Oh, yeah, Honorable Christian, I can't see your hand here from my system, but go ahead and ask that point of clarity-seeking question.
Chairperson, I just wanted to, yes. Sorry, I couldn't unmute myself at the table had to. I just wanted to know if this was our last presentation from our stakeholders, Chairperson.
No, it's not. We still have two more to go.
All right. No, I'll wait until the end. Thank you very much, Chairperson.
Now, I thought you wanted to ask a point of clarity on the speaker on the floor.
No, Chairperson.
All right, thanks a lot. All right, thank you. This opportunity now goes to South African Education Development Trust, SAOAOT, as represented by Mayor Susan Mellet. Over to you.
Thank you, Chair. I'm just sharing my screen here.
Yeah.
There you go. Can you all see my screen?
Yeah, we can see you. We can hear you and hear. Yeah, we see and hear you.
Thank you, Chair. Thank you, wonderful Chairperson, members of the Parliamentary Select Committee, and colleagues. As the previous presenters also stated, it is an honor for us to address this committee on behalf of my organization, SAET, and we appreciate the opportunity to participate today. Public participation in policy decision-making and local governance is regarded as a key principle in our constitutional democracy in the new democratic South Africa, and it's therefore a big privilege for us also to contribute to the dialogue regarding the Bala Bill. Firstly, I would just like to give a brief presentation of who SAET is or SAET. We are the South African Education Development Trust, or in Afrikaans, the Suid-Afrikaanse Onderwysontwikkelingstrust. We were founded in 2011, and the objective of this trust is to give support in the form of training to schools, school governing bodies, or learners, especially in the poorer communities, and to improve the quality of governance and management of public schools in South Africa. Our main focus is the training of our parents on our SGBs and also the training of learners in the RCLs. It seems to me like I'm going to give a brief summary of all the previous presentations because the points they've pointed out are also the points that we feel very strongly about. Now, education is the most powerful weapon which one can use to change the world. This quote by Nelson Mandela is one of the most famous sayings on the value of education. And at Sahut, we believe that the education laws are one of the important tools with which one can sharpen this weapon and increase the value of education. And I think ISASA also referred to this. The memorandum on the objects of the Basic Education Laws Amendment Bill states that these proposed amendments should ensure that systems of learning and excellence in education are put in place in a manner which respects, protects, promotes, and fulfill the rights to basic education as enshrined in Section 29(1) of the Constitution. Now, in the majority of our schools, excellence in education is achieved through, amongst other things, the service of well-functioning school governing bodies. These proposed amendments must therefore, in our opinion, not interfere or undercut with the rights and the responsibilities of school governing bodies, but it must rather support, strengthen, and also reinforce the roles of our governing bodies. We therefore ask the question, are the proposed amendments a hindrance or helpful, especially with regard to the roles and the responsibilities of our governing bodies? The first hindrance for us, and a few of the presenters referred to this as well, it's the capacity to implement the proposed amendments. Now, SAHED serves the needs of our poorer communities, and we are seriously concerned that the proposed amendments will place a heavier burden on these poorer schools due to the fact that the provincial education departments may not have the capacity or the resources to manage and execute these additional duties that the amendments will place on them. A heavier financial burden will also be placed on our provincial education departments. And schools do not have the additional resources to implement these obligations. Has the budget implications of these amendments been considered, and are the provincial education departments fully aware of the budgetary implications for them? We therefore also request a cost estimation to be done to determine the full implications of these proposed amendments. We are of opinion that it is necessary for the department to assess the economic feasibility of the proposed amendments in each province to ensure that the enhancements to these basic education laws are not only well-intentioned, but also realistic and implementable across our diverse educational landscape. Now, some of these amendments that will place a heavier duty on our schools includes making grade R compulsory. We do support this principle, but we are also seriously concerned about the implementation as the previous presenters as well. Additional posts, additional classrooms, and additional learner and teaching support material will need to be supplied. And schools cannot use the current funds to cover more expenses if there hasn't been made budgetary provisions for these additional resources. Secondly, submitting the admission and language policies. Needless to say, this will place an administrative burden on the provincial departments. For example, in KwaZulu-Natal alone, almost 11,600 policies will need to be submitted and considered by the HOD, or as the SAOU pointed out, most probably the local district office, every 3 years or once promulgation of the Amendments Act. What are the cost implications for our schools? Has that been determined? Also, additional costs will be needed where schools are directed to also implement a second language. And thirdly, the centralized procurement of LTSM. I'm sure I don't need to remind you of the past failures by the provincial departments to deliver LTSM. In the matter of Minister of Basic Education versus Basic Education for All, it was highlighted that those adversely affected by the state's failure to provide textbooks were primarily from the poorer communities and predominantly, if not exclusively, our Black learners. We would also like to propose an alternative, and this has been proposed by previous presenters as well. where schools can procure LTSM on their own behalf, but they still have the option to opt in from the department's procurement if it is in the best interest of the learners. And again, we urge the department to ensure that before implementing this proposed amendment, that an audit be done to ensure that provinces are ready and able to supply not only LTSM on time, but to ensure that the LTSM that will be supplied is of a high quality and standard. Now, the second hindrance for us is that the proposed amendments or certain proposed amendments are an attempt to gain control over the functions of our governing bodies. The importance of governing bodies in the education system has been firmly established in White Papers 1, White Paper 2, South African Schools Act, and numerous court cases. Parents, and again, this has been stated before today, precisely because they are parents, have the right to decide about their children's education. In the previous dispensation, prior to the commencement of the Constitution, the state laid claim to totalitarian powers, but our Constitution came and restored the balance. In White Paper 1, on page 21, it was stated that parents have the inalienable right to choose the form of education which is best for their children, subject to reasonable safeguards which may be required by law. The parents' rights to choose includes the choice of language, cultural or religious foundation of the child's education, with due respect to the rights of others. We are of opinion that certain proposed amendments reflect an attitude that the state is again the ultimate bearer of powers, and that the state may simply take away certain powers from our parents. The proposed amendments to the admission and language policies is one of these amendments attempting to take control over the role of our school governing bodies. Through the amendments, departmental officials are attempting to take control over the roles by governing bodies, the role that they play in the admission and language determination through applying a one-size-fits-all approach. Now, the preamble to the Bala Bill even states that the aim of the bill is to enhance the authority of the head of the department in relation to the admission of a learner to a public school after consultation with the governing body of that school. Now, this implies that only consultation is required. No consensus or agreement is needed. Now, if this is not a claim to totalitarian powers, I really do not know what is. Governing bodies will become mere pawns in the hands of our officials. And it has also been stated, I think, by AfriForum, that an HOD's hands are not tied if he or she is of opinion or has a reason to believe that a school's policies are not in line with the Schools Act or other applicable laws. The SGB's exercise of power in formulating policies constitutes administrative action, which is reviewable in terms of the Promotion of Administrative Justice Act. Therefore, if an HOD has reason to believe that the SGB's policies are unreasonable, it may review these policies and the policies may be set aside. And the HOD may also, in terms of Section 22 of the South African Schools Act, on reasonable grounds, withdraw the function of the school governing body to determine policy. The proposed amendments are therefore redundant and not in line with the spirit of cooperative governance to which FEDSAS also refer to. We therefore request the removal of the proposed amendments to Section 5 and the relevant sections, Section 6. There are still public schools that do not have basic facilities such as clean running water, flushing toilets, safe school buildings, or even enough or adequately trained educators and staff members. And I quickly just want to refer you to a few of the court cases proving the failure on the part of the departments to supply basic services or resources to schools. In 2022, the case of Kula Development Project versus Head of Department, Eastern Cape Department of Education. In this case, the department failed to deliver textbooks and stationery to schools in the 2022 academic year. In 2020, there was a case, Centre for Child Law and others versus the Minister of Basic Education and others. In 2016, the Eastern Cape Education Department determined that funding was made conditional funding for learners with no identity numbers would be withheld until corrected. Failing, by 17 June 2016, these learners would be removed from the enrollment system. This policy was held to infringe constitutional rights and was set aside. Also in 2020, in VM and another visit the MEC, Eastern Cape, a learner had drowned in a pit toilet at a school in the Eastern Cape. And in 2019, we all remember the case of Kumapi and others versus the Minister of Basic Education, where a learner also drowned in a pit toilet. And the Limpopo Department of Education could have put toilet seats on the pit toilets for a small amount, but it failed to do so. And then in 2015, the Minister of Basic Education and others versus Basic Education for All, where the department failed to deliver textbooks in Limpopo. Resources that will now be channeled to the implementation of certain proposed amendments can rather be spent where it is most needed to serve the best interest of our learners in schools. Money, time, and resources should rather be spent to ensure that the basic rights of learners are being upheld, rather than diminishing the rights of the parents by taking away the legitimate rights of our governing bodies. We are also of opinion that certain proposed amendments will be helpful, and I quickly want to refer to those. First is the expanding the definition of corporate punishment. This expansion will allow for more efficient prosecution, and it will prevent possible grey areas in this regard from being exploited. It's in the best interest of the child, a fundamental constitutional right, and it does support the objective of upholding the rights of our learners. And as I've mentioned earlier, making grade R compulsory. If our earlier mentioned concerns are adequately addressed, this amendment will bring clarity on the subject. Must a learner attend grade R or not, and who will provide educators? And it will also prepare our grade R learners for grade 1, and this is very necessary for early childhood development and in line with our National Integrated Childhood Development Policy. Thirdly, amendment to the definition of loan. The expansion of this definition of loan by excluding the permission for the daily operational costs will allow for our governing bodies to continue with their daily business without unnecessary hold-ups. This amendment supports the objective to promote parents' acceptance for the responsibility for the organization, the governance, and the funding of schools in partnership with the state, as it will allow parents of governing bodies to conduct their businesses without the unnecessary frustrations, which then in turn will encourage the parents to continue the membership of the governing body thoroughly and with due diligence. And thirdly, the proposal of admitting learners without documents. This proposed amendment is also in line with current precedents as set by our courts, and it promotes the learners' rights to access to education. Now, these are just our comments and our concerns in a nutshell, and I would like to refer the committee to our written submissions for a detailed explanation of everything. Thank you very much.
Thank you very much, Mayor Susan Mallet. Thank you for your presentation. Honourable members, are there points of clarity on this presentation? We will, as a committee, engage with this, with your presentation when the time comes. And obviously, Parliament sittings are on in the public domain. So when people want to hear what the deliberations are, they can easily connect to that. Is there any clarity-seeking question on this presentation? Let me check. I don't see any hand. Yes, thank you very much to the South African Education Development Trust. May we invite the ActionSA on the platform as represented by Mr. James de Villiers. Over to you, Mr. de Villiers, ActionSA. Your 30 minutes.
Good afternoon, Chairperson, and thank you so much. My name is Angela Sobey, and not James de Villiers. I am the ActionSA representative on our education policy. Honourable members and fellow South Africans, thank you for the opportunity to present the committee with ActionSA's submissions to the Basic Education Laws Amendment Bill. ActionSA is a political party that emphasizes the utmost importance of a highly functional education system. We understand that without a basic education system that empowers young people to pursue their life goals, we cannot hope to address the triple threat of unemployment, inequality, and poverty. South Africa's basic education system is failing to empower our young people, and urgent action is needed in this regard. The changes to the system as proposed by the Bella Bill, however, are not what is required to improve the performance of our education system. Rather than deal with the root causes of the poor performance of our education system, the bill recommends a range of interventions that will actively cause damage to the functioning of our education system. While we acknowledge the need to do a broad-scale review of the regulatory framework regulating South Africa's education system, the Bella Bill is merely a continuation of the ruling party's ill-informed attempts to address systemic and operational issues with legislation. It is unfortunate that the Department of Basic Education uses rather meager resources on superficial changes that will, at best, address a few symptoms of the broader failures of the education system. While South Africa has made great strides in improving access to education, we are still failing to provide access to quality education. It is imperative to South Africa's future that all members of South African society rally together on a common cause of rapidly improving the performance of the South African education system, so that we create a South Africa where each generation experiences a better life than those before them. ActionSA's submission to the Bella Bill adds our voice to the widespread objection to the bill offered by civil society and education experts. Besides objecting to the flaws of the bill, we will provide tangible recommendations to the Department of Basic Education that will contribute to improving access to quality education. Members of the committee, the reality, which I do hope we can all acknowledge, is that the education system in South Africa is failing our children. Weak institutions, too much undue influence from unions, teachers with limited knowledge and skills, and wasted learning time have resulted in poor educational outcomes. A recent study found that 8 out of 10 children in public schools cannot read for meaning by the age of 10. The curriculum does not focus on skills development and fails to equip young South Africans with the knowledge and skills to participate in the economy. These problems are worse in historically disadvantaged areas as well as rural areas, leaving millions of young South Africans excluded from the economy and trapped in a cycle of poverty and unemployment. ActionSA believes that education is the key to a better future, and we see the transformation of our education system as our key priority. We believe that only when all South Africans are empowered through quality education can we hope to achieve shared prosperity and economic growth. Access to education is not enough. We need to ensure that everyone has access to quality education that empowers them with the skills to be successful and develop as individuals. Quality education involves the whole community. This means that we need to make sure that every South African child has access to a lifelong educational journey that empowers them to develop their skills and pursue their dreams. We believe that it takes a village to raise a child, and that must be reflected in our education system. Everyone needs to get involved to build a brighter future for our young people. We believe that access to quality education ensures that children establish the strong foundation required for a productive educational journey from a young age. This includes ensuring access to nutrition and fostering a safe and healthy learning environment. Furthermore, politics and unions get in the way of quality education. Labor unions wield excessive influence over the education system, leading to significant inefficiencies in schools and the unproductive allocation of financial resources. ActionSA's major objections to the bill relate to the inappropriate power and authority this bill would give to the Department of Education and the Minister of Education. South Africa's education tool has in the past been used by the apartheid government as a tool to oppress millions of South Africans. And it is currently being used by the ruling party as a political tool to win the favor of trade unions and ensure that young people remain reliant on the state for assistance. Within the context of the abuse of the education system for political purposes, we believe that the state's role should be curtailed and not expanded. The state's role should be focused on the provision of infrastructure, ensuring compliance with minimum standards, training and empowerment of educators, and providing resources to public schools. The state, and especially not the Minister of Education, should not have the authority to interfere with the day-to-day management of schools. Competent and resourced school inspectors should provide oversight over schools to ensure that they fulfill their duties and are appropriately managed. Rather than impose mere mechanisms for political interference, we should be eliminating the broad range of mechanisms the government and politicians currently have for interfering with the education system. We are opposed to the determinations of the bill that give the minister the authority to interfere with the appointment of school governing bodies, to make determinations impacting school districts without proper policy guidance, and to appoint persons or organizations to advise the minister on matters of the curriculum without transparent and clear procedures for doing so. Decisions about our schooling system should no longer be made in secret, where powerful interest groups can manipulate decisions in their favor. Rather, we should allow appropriately trained and skilled educational experts to guide South Africa's education policy development and make informed recommendations on the curriculum. Entirely non-partisan technocrats should regulate and govern the education system. Labor unions should no longer be able to protect teachers against accountability. Members of the committee, allow me to outline the following key areas of objection. Socioeconomic impact assessment. Firstly, the socioeconomic impact assessment accompanying the bill is deeply flawed and was conducted before the COVID-19 pandemic. We know how much has changed since then. The pandemic has had a fundamental impact on our schooling system, and our circumstances have changed so much that the SEIA is now outdated. The SEIA's root cause analysis of the socioeconomic problems the bill seeks to address does not adequately capture the DBE's performance and systemic challenges that impact the problems. Without a realistic analysis that includes appropriate self-criticism, the bill's recommendations are based on flawed reasoning. The SEIA also does not adequately estimate the fiscal and economic impact of implementing the bill. Definition of basic education. We have outlined that the bill does not sufficiently address the definition of the right to basic education, and that the definition should be expanded to include reference to auxiliary factors that impact access to education, including transport, infrastructure, and qualified and adequately resourced teachers and educators. Compulsory grade R. We welcome the introduction of grade R as part of basic education. It is critical that children attend school as soon as possible. Incorporating grade R as part of basic education, if done correctly, will ensure better alignment across the child's learning journey. However, Making grade R attendance compulsory should be accompanied by interventions that expand true access to education. The bill is also not clear on the alignment of the grade R curriculum with the rest of the basic education curriculum, and is also unclear about the age of entering grade R, and this must be clarified before adoption. Furthermore, the true financial cost and fiscal trade-offs of incorporating grade R into the basic education system must be established before the adoption of the bill. Criminal sanctions. Introducing further criminal sanctions will likely disproportionately affect poor families facing socioeconomic barriers to ensuring school attendance. Rather than increase criminal sanctions, we need to improve the enforcement of existing sanctions against parents that malignantly prevent their children from attending school. Sorry about that. Language policy. ActionSA opposes the transfer of authority to set a school's language policy to the Department of Basic Education. We acknowledge that school governing bodies may use language policy to exclude learners of specific language groups. However, the current suggestion that the DBE must have full control over language policy is political overreach and might have adverse impacts on schools catering to specific communities. We believe instead that accountability is more important and more practical in this instance. There should be appropriate oversight mechanisms that ensure school governing bodies adhere to minimum standards and are held accountable. Learning disruptions. We welcome the expansion of penalties imposed on those who maliciously disrupt schooling and will support any expansion of criminal sanctions against those that maliciously cause harm to school infrastructure. However, the current wording of the bill does not sufficiently protect the right to peaceful and legal protest. The right to association and peaceful protest is a fundamental aspect of South African democracy, and we cannot allow the broad definition contained in the bill to curtail that right. Sale of alcohol. We cannot support the selling of alcohol at schools in the absence of very clear, strict, and detailed conditions applicable to exemptions of the ban. No alcohol should ever be sold on school premises where children under the age of 18 are present or may reasonably be expected to be present. Homeschooling. ActionSA opposes the limitations imposed by this bill on parents' ability to decide whether to homeschool their children. Homeschooling remains the best option for many children for many reasons, and we must trust that parents know what is best for their children. We do not oppose the requirement that homeschooled children should be registered with the DBE. Where children are homeschooled, appropriate but non-intrusive oversight mechanisms should be in place. However, we are opposed to giving the Minister of Education broad powers to determine regulations about the administration of homeschooling, as this will amount to political overreach. Members of the committee, in light of the concerns highlighted with regard to the current format of the Bella Bill, and the urgent need to address the actual needs and realities of our education landscape, ActionSA would like to table the following recommendations with respect to the Bella Bill. Firstly, any changes to the education system should ensure that the grade R curriculum is age appropriate and create the foundation for further skills development and educational attainment. ActionSA submits that the definition of corporal punishment should be aligned with the definition developed by the UN Committee on the Rights of the Child and should be expanded to include threats of physical or corporal punishment. The definition of prohibited punishment should be expanded to include a prohibition on emotional and psychological abuse. This form of abuse should be clearly defined to ensure that educators maintain fair and just mechanisms to discipline students. We must submit before the committee that with respect to the language policy, that the DBE should adopt clear and appropriate mechanisms to determine the fairness of a school's language policy. We believe that language policies should be determined by data, including catchment area population statistics and the availability of alternative options catering for various languages. When it comes to the management of schools, the Bella Bill should ensure, excuse me, when it comes to the management of schools, the Bella Bill should ensure that school governing bodies, educators, parents, and the school's broader community have a greater ability to contribute to the well-being of schools and learners. But beyond our recommendation regarding the Bella Bill, ActionSA offers the following recommendation to fix our education system, calling on the Department of Basic Education to implement the following interventions: to depoliticize the education system by removing undue political influence by political groups, politicians, and unions like SATU, to ensure educational decisions are made by education experts with the best interests of the children in mind, to create a single Department of Education by merging the current departments of basic and higher education and training, to improve the alignment of educational outcomes across the educational lifespan, to improve teacher training and support by increasing the number of trained teachers through reinstating teacher training colleges, provide better oversight over training to ensure that teachers meet the standards needed for quality outcomes, expand support for ECD, early childhood development, by investing more in early childhood development centers, providing additional training for ECD practitioners, and ensuring children have access to food and nutrition while at school, to focus on reading and numeracy, making improving reading and basic numeracy top education priorities to ensure a strong start to the educational journey. Ethic and moral education, schools must assist in raising patriotic South Africans with a strong ethical and moral code. The curriculum must include civic education, while children should be given the opportunity for morning prayer or reflection or spiritual reflection according to their individual beliefs. School performance. We need to reintroduce school inspectors to ensure that all schools have quality teaching. We need to empower principals with more control over teacher performance and hold them accountable for poor performance. Curriculum reform. We need to reintroduce reforms to ensure that young people's study gives them skills to find jobs or to advance their studies. We cannot only focus on academic knowledge. We must focus on life skills and economic skills. This must improve employability and promote entrepreneurship. Infrastructure priorities. We need to expand the budget for water, sanitation, and broadband connectivity, the internet. We must provide safe and dignified ablutions, such as toilets and broadband internet access for all learners. We need to eradicate pit latrines and mud schools. We cannot, in this day and age, still be having children learning in mud schools and falling and drowning into pit latrines. We need to provide free sanitary products. We need to ensure that girls do not miss a day of school due to a lack of sanitary products. Menstruation is not a choice. And in the same way that condoms are being made freely available, so sanitary towels need to be made freely available. We need to allocate more money for educational institutions by establishing additional universities, technical colleges, and teacher, nursing, agricultural, and policing colleges. As I conclude, we welcome the DBE's acknowledgement that South Africa's education system is in disarray. However, the Bella Bill is an ill-fated and desperate attempt by the DBE to fix the education system by tampering with what is not broken rather than fixing what is. At its core, the bill is ignorant of the root causes of the education system's failures, despite the availability of comprehensive research by independent experts outlining the core challenges that need to be addressed. The only thing the Bella Bill achieves is to allow the DBE to fool themselves into thinking that they are doing something. However, the bill in its current form will, at best, do nothing to improve the performance of our education system. At worst, it will further harm our education system and drive school performance down to the lowest common denominator. As I conclude, ActionSA is committed to improving South Africa for all who live in it, and we are more than happy to work with the Department of Basic Education to ensure that we fix our education system together. Thank you so much for your time.
I'm unmuted now. All right, thank you. ActionSA, thank you for your presentation. Are there members, any member wants to ask questions on clarity and related to the presentation of ActionSA? You are free to raise your hand. Let me go into the system. I do not see any hand now on this matter. In the absence of any hand on this matter, there was a hand that was raised by Honorable Dalmain Christians. Is your hand still, do you still need the platform, Honorable Christians? All right. In the absence of that for now, let me take this opportunity.
My apologies, Chair.
Yes,
Honorable Christian's hand is up.
Okay, Honorable Christians, the floor is yours, man. What are you raising?
Yes, no, thank you, Chairperson. Apologies about that, but it seems we can't unmute ourselves. So I just want to also tell the table just to have a look at that for the future, please. But all I wanted to say, Chairperson, was just thank you to all our stakeholders today who shared their various concerns to us on this platform. And I think it is evident that there are many common concerns that deserves our careful consideration as a select committee. So the issues raised here today by all the stakeholders are obviously a testament to the diverse perspectives that shape our educational system currently. And I just want to reiterate that as we move forward as a select committee, it is imperative for us that we actively engage with due diligence on all the inputs given here today. And this has to involve a thorough examination of all the concerns raised and a commitment from us as members of this select committee to ensure that the bill is refined to the best interests of all our constituencies. And lastly, Chairperson, just in the interest of transparency and in the interest of inclusive governance, we must ensure that the voices of those who rely on our decisions are not only heard, but that we as a select committee of the NCOP take them genuinely into account. And I therefore propose that we approach the next steps of this bill with a commitment to addressing the valid concerns as expressed today. Thank you very much, Chairperson.
Is there any other member of the committee who would like to say something before I close? I make my remarks to close the meeting. In the absence of any, let me take this. Firstly, I'd like to thank you, the presenters, for contributing positively to this important process of oral submissions. All the constructive feedback is important because it also highlights the voices of ordinary South Africans in lawmaking. All your input has been captured in detail by the parliamentary officials on the platform and will be deliberated upon by the Select Committee and the National Council of Provinces. We will keep you up to date on any further developments from here on, and we trust that the processes like this ones will shape a progressive future of the South African educational landscape. Thank you very much. Let's say all our guests are released from the meeting. Thank you very much. And then the members will remain so that we deal with in-house issues. Thank you very much. You are all released except members of the committee. You may log out. Meskaka, Noltando, do we have minutes, the last meetings? And they say, hello?
The minutes will be adopted in the next week, Chair. I didn't put them for adoption.
All right. All right, thank you. So thanks everybody till we meet again tomorrow in the next meeting. Have a good day. Bye, thank you. Bye-bye. Ciao.
Bye, thank you, Chair.
Yeah, yes, very good. We have a sitting here too.
Recording stopped.
It's
Tomorrow
so
we
hot
start
in the
what
village.
time?
Eh?
Tomorrow that we start what time?
Tomorrow?
At 2 o'clock.
Is it 2? Oh, okay.
No, tomorrow we're starting at 2, I guess.
Okay.
Yeah.
All right. Thank you, Chair, but it was very long, but yeah.
Okay, Pele.
It was very long, but okay.
Yeah, it's okay. Let's go.
Sharp.
Sure. See you in the chamber. Are you in Cape Town?
Yes,
All right.
I'll be there. Sharp.
Sure. Bye.
Sure. Bye.